and will be used against you. You also have the right to an attorney at this proceeding today. All participants, this particular proceeding is being broadcast over the internet. It is also being recorded. That means any member of the public can log on and watch this particular proceeding. When I ask you if you understand your rights, those are the rights to which I'm referring. Those who receive a signature bond will be reset for the notice. Ms. Lewis, those who receive a surety or cash bond, so what SAP calendar will they be reset? You're muted again.
I'm sorry, Judge. Hold on.
Well, while Ms. Lewis is beginning, I want to ask all defense counsel, is anyone going to require the assistance of a Spanish interpreter today?
It'll be January the 5th, Judge.
All right, so those who receive a surety or cash bond will be reset to January 5th SAP calendar. And I renew my question. Defense counsel, anyone needs the services of a Spanish interpreter today?
No,
Yes,
Judge,
sir.
Yes. How many
Yes.
positions? I'm sorry, say again.
It's two defendants that needs Spanish interpreter, Judge.
All right, and Ms. Hogue, do you represent those defendants? And have you already interviewed them?
Your Honor, I don't represent them. I believe Ms. Cook does.
Ms. Cook, you represent those defendants?
Yes, Your Honor, and I have not interviewed them.
Okay,
Ms.
we're ready
Lewis.
for a breakout session in courtroom number 3.
Okay, Ms. Lewis, are we gonna have the services of a Spanish interpreter
I
today?
have one now. If y'all guys gotta give me a second.
I'm sorry, say that again. I couldn't hear
I
you.
have to get one now because we just got the request just now, so we have to get one. So it's gonna be.
Okay, I figured that might be a problem. This calendar is quite long.
That it is, and I'm a one-man show today, so I got Michael working on the sideline, so maybe he got the message and he's gonna maybe assist, but I'll
All
try.
right, so we'll see if we have interpretation today. It's our hopes that we do, because it's Christmas Eve. It may not happen. If those are the people who need interpretation already in courtroom 3, is everybody
Yes.
who needs? Okay, that's helpful. All right, so let's begin. Who do we have at courtroom 2?
We have position 1, Mr. Bailey.
All right, good afternoon, Mr. Bailey. Your case is 22 CR 008475F. In this case, you're charged with willful obstruction, failure to report striking a fixed object, and reckless driving with the offense date of February the 9th of 2020. Do you understand your rights? I'm sorry, yes? All right, everyone, please say yes. We need to get through this as quickly as possible. All right, Mr. Howard.
Second arrest, 2018, possession of marijuana with intent. That was dead, docket. He went to
Okay.
felony earlier and got an $18,000 good bond. That's it.
Okay. Thank you. Whose case is this for the state?
It's Ms. Brown.
All right, Ms. Brown, please proceed.
Yes, Judge. On this day, Mr. Bailey was traveling at a high rate of speed on traveling southbound on Metropolitan Parkway. He attempted to make a right-hand turn and struck a telephone pole, and the police, when the police approached, he jumped out and fled on foot. And so we're just asking that the bond remain the same. I believe it's a $6,000 surety.
All right, thank you. Ms. Hogue, is this your client?
Yes, it is, Your Honor. And Mr. Bailey is 22 years old, Your Honor. He is a lifelong resident of Georgia. He has a high school degree from Carver High School. He has a semester in at Atlanta Metropolitan State in Business Administration. He is currently working as a prep chef for a foodery near Lenox, where he's been there, as well as he works as a host and doing other food service. He's been consistently employed since he has graduated high school and attended college. As you can see, this is just his second arrest, and he is facing a significant bond. The charges here, I would like also to note, are from 2020, Your Honor. This incident happened on 2/9/2020, so we're getting close to 3 years old now. So I do believe that for these particular charges, a signature bond is warranted. And if not a signature bond, Your Honor, given his limited criminal history of a possession of 2018 possession of marijuana, and the fact he does have significant felony bonds of 18,000, which I'm sure more than will assure his appearance at court, I do believe minimum bonds of 500 each is more than appropriate for a 3-year-old charge.
All right, I'm inclined to agree. Ms. Hogue, defendant will receive a $1,500 surety bond, 500 on each charge. And he's of course to have no weapons, drugs, or alcohol. Anything further?
Nothing from the defense.
All right.
Judge, you
Best
said
of luck.
500 on each charge,
Yes, so 15 total, 500 each charge.
so that's a $1,000 total bond?
It's 3 charges.
Uh,
Willful obstruction.
oh, that's right, it's 3. I'm sorry, Judge, I see.
You're okay, 1,500 each charge. I mean, 1,500 total, 500 each charge. All right, who do we have next?
Position 8, Mr. Cooper.
Yes, Judge, I'll be representing Mr. Cooper, Attorney Scott Smith.
Okay, good. I was gonna ask if we could do your case next, Mr. Smith. Will you enter your appearance and then we'll get to history?
Yes, Judge.
All right, go ahead, Mr. Smith.
Okay, thank you, Judge. This is Raymond Cooper. His family is present, actually. His father, who's in town, is their daughter's birthday. She's 2 years old. The alleged victim is also present. She wishes to have contact with him. Big misunderstanding, family coming in town.
Hold on, Mr. Smith. Hold 1 second. Go ahead, Mr. Howard. Can I have the history, please?
Y'all called the case already? 11 total. August 2021, 3 counts actually, theft by receiving. 2 was felony, 1 was misdemeanor. It's 21 CP. He has an open 21 CP 202584. That's theft by receiving, possession of a firearm during a commission, possession of a vehicle with an altered VIN, and misdemeanor possession of marijuana. He got a history out of Illinois, Florida, and Texas. 2016 out of Illinois for battery. It says stricken off with leave to reinstate. 2015 aggravated discharge of a firearm. I think that was a conviction. 2013 obstruction conviction. 2011 domestic battery. It just says direct file with court. 2010 ag battery, direct file with court.
Okay, that's good. All right, Mr. Cooper, your case is 22 CR 0084. I'm sorry, 80E. In this case, you're charged with battery family violence with the offense date of July the 21st. You understand your rights?
Yes,
Thank
ma'am.
you.
I'm sorry, I mean, Mike was muted.
Thank you. All right, Ms. Brown.
Yes, Judge. In this case, when the officer met with Miss Amara Brown, AMARAH, she advised that her children's father, Mr. Cooper, they had got into an argument about damage to her vehicle, and he got enraged, and he began grabbing her and banging her head against the wall and the floor, and she sustained a visible laceration to her left hand and upper lip. Judge, we have concerns about Mr. Cooper being a flight risk, given that he has criminal history out of 3 different states. We also have concerns as to intimidating a witness, being that he has several violent charges in his history. I understand that she doesn't want, she indicates that she wants contact with him, but we do have concerns about that. And also that he would be a risk to commit further felonies, given that he has 11 cycles. So we're asking for a $3,500 surety bond, no further contact with Ms. Brown, a stay away from the location if he does not live there, which is 2144 Peachtree Road, and no alcohol, drugs, or weapons, Judge.
All right. Is Ms. Brown present on the Zoom conference? Mrs. Smith, is she there? Is she there?
She's present in the courthouse, in the jail.
Oh, she's at the jail.
Yes, Judge.
Ms. Brown, do you wish to make a statement?
Good morning, Judge. I'm here for Donna Brown.
No,
Sure.
not that
Oh,
case.
okay. All right.
Amara Brown.
Okay.
I'm sounding, is Miss Amara Brown at courtroom too?
She stood up, Judge, in the back in the glass.
Okay, they're gonna let her make a statement.
Yep, of course, I'm the one that slows everything down before Christmas. I'm sorry.
I have to go stand over here by the wall. Stand by it. Yep.
All right, please raise your right hand if you'd like to make a statement, Ms. Brown. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. What I'm most concerned with today is whether you wish to have any contact with the defendant. What would you like to tell me at this time?
Yes.
I said, that's all you'd like to tell me? Yes,
Oh,
you'd like to have contact?
Right. We live together, we're raising children, so having contact would be important for raising our child.
Okay, thank you. I appreciate you coming to court and making that statement. Mrs. Smith, please proceed.
Okay, yes, Judge, born in 1990, lives here in town. The two of them are on the lease together. They both have child's 2 years old, actually 2 years old today. Family's in town for Christmas. That's his dad in the back behind the glass. And verifiable employment here in town, has some college, no FTAs on his record. I represent him on the other state court matter unrelated to a domestic case. She wishes to have contact. They need to have contact for purpose of raising the child, especially over the holidays. They don't have childcare. Dad's only temporarily in town to assist with his son and be here for the birthday party. But other than that, I'm fine with the state's request for the amount. We're just asking for no violent contact.
All right. All right, at this time, defendant will receive a $6,000 surety bond. He's to have no further violent contact with the victim and have no alcohol, drugs, or weapons.
Judge, do I draft the order?
I believe you'll need to. Is that correct, Ms. Lewis? Oh, no, Ms. Lewis will do it.
Oh, Ms. Lewis, you're a saint. Thank you so much.
All right, Mrs. Smith, if that concludes your business before the court, you can be excused.
Okay, Merry Christmas, Judge. Thank you.
Take care. Merry Christmas. I see that Ms. Rutledge is asking for a breakout to speak with her client. I don't know if that's going to be possible. Where is she's at the South Annex? Is that where Donna Brown is?
No, Your Honor, I believe I spoke to her earlier. I'll be glad to talk with Ms. Rutledge as well. I wasn't realizing she was represented, but I believe I spoke with her here, not at South Annex.
She's here in courtroom 3, Judge.
Yeah.
Okay, so can courtroom 3 be placed in a breakout room with Ms. Rutledge so she can speak to her client?
No, ma'am, she can call her and give her the phone number, please.
Okay, I figured that might be the case. Ms. Rutledge, they're going to give you a phone number to give your client a call, okay? All right, who do we have in courtroom 2?
Position 22, Mr. Poirier.
All right, Mr. Poirier, your case is 22 CR 008462C. In this case, you're charged with theft of service with the offense date of November the 6th. Do you understand your rights?
Yes, ma'am, I do.
All right, this is his first arrest, so we'll go right to you, Ms. Mitchell.
Hi, Your Honor. In this case, the defendant left the Sivas restaurant located at 794 Juniper Street, Northeast Atlanta, Georgia, without paying for their services and took an unknown amount of cash from the table. One of the staff members at the establishment stated that the defendant came with 2 other people. The 2 other people left, stating that the defendant would pay the balance before leaving. The defendant then confirmed that he will pay, but that he was waiting for a transfer to go through on his bank. The staff member that was hosting that table left, and when she returned, the defendant was gone along with the cash that was left along by the 2 other patrons that have left previously. So a total of $198.44. That balance was left unpaid. The state's recommendation in this case is going to be a $2,000 surety bond, to stay away from the incident location, Sivas restaurant, and no alcohol, drugs, and weapons. Although this was a first arrest for the defendant, we are concerned, well, not a concern, but the defendant, not only did he leave, he also took the cash that was left for the restaurant, in addition to not paying for his share. So because of that fact, we are recommending a $2,000 surety bond. Thank you, Your Honor.
All right, thank you. Is this your case, Ms. McLeod?
No, Your Honor, this is Ms.
Oh.
Cook's place.
All right, Ms. Cook, please proceed.
Yes, Your Honor. Mr. Puryear is 31 years old. He currently, is my understanding, he just recently started a new job at the DeKalb County Housing Authority. He is gainfully employed. He's been in Georgia since July of 2021. He has a high school degree and some college. He's here in Georgia. He lives in Georgia with his mom and little brother. Obviously, he maintains his innocence as it relates to the allegations charged against him. This is his first arrest. He has no prior criminal history. We would be asking the court for unsecured judicial release on this matter. Thank you.
All right, at this time, defendant's gonna receive $198 surety bond, and he is to stay away from the restaurant on Jennifer Street and have no alcohol, drugs, or weapons. Is there anything further?
No, Your Honor. Thank you.
All right, best of luck to you, sir. Who do we have next?
You said 198?
Yep.
Okay.
All right, who do we have next? Best of luck to you, sir.
I'm sorry, position 28, Mr. Williams.
All right, good afternoon. Are you Sylvester Williams?
Yes, ma'am.
All right, do you understand? Your case is 22 CR 008473E. You're charged with obstructing a highway, a street, or a public passage with the offense date of December the 21st. You understand your rights?
Yes, ma'am.
All right, thank you, Mr. Howard.
64 total.
Last 5 years and anything relevant to this charge.
Last arrest was in November for trespass out of DeKalb. He got over 50 arrests out of California. 2019 possession of drug paraphernalia. 2019 parole violation. 2018 parole violation. 2017 suspended license. 2017 another parole violation. 2016 DUI drugs. So yeah, he got history of that, you know.
Okay, I think we've got the picture. Oh, I see the interpreter is on the line. Can the interpreter now be placed into the breakout to help with the interviewing of the clients? Is that possible?
Yeah, I just need to know what.
Well, let me.
Yes, Judge, we're ready. We're ready in courtroom number 3. Thank you.
Okay, Madam Interpreter, I'm gonna go ahead and swear you in now. Please state your name for the record.
My name is Adriana Chansey, Your Honor.
Miss Chansey, will you please raise your right hand?
Yes, ma'am.
Do you swear and affirm that today you will make an accurate translation from Spanish to English, English to Spanish, for the best of your skills, knowledge, and ability?
Yes, Your Honor, I do.
Thank you, Miss
You're
Chansey.
welcome.
If Miss Chansey could be placed in the breakout with courtroom 3, who needs to do the interviewing as well? It was Miss Cook.
It was, Your Honor, but Mr. Williams is also my
I
client.
was gonna say that. Let's finish Mr. Williams, and then we'll have you go into the breakout, and we'll take all the other cases that are not yours. Okay. All right. I'm sorry. I just heard the history. Miss Mitchell, this is your case.
Yes, Your Honor.
Okay, please proceed.
Yes, Your Honor. In this case, officer responded to a phone call describing defendant with several bags harassing people at a parking garage at 75 MLK Junior Drive, Southwest, Atlanta, Georgia. Upon arrival, the defendant was on the sidewalk with several of his bags and personal items scattered across the sidewalk in a manner that was obstructing reasonable pedestrian traffic. The defendant was asked several times to gather his belongings from the sidewalk and to leave the area, but he refused. Your Honor, there is a current bond of $600 surety on this case, and the state requests that that bond remain the same with a stay away from the incident location and no alcohol, drugs, and weapons. You've heard from pretrial, the defendant's criminal history. He has a lot. And so being that he has an open case in DeKalb for criminal trespass just last month, we're requesting that the $600 surety remain. Nothing further, Your Honor.
All right. Ms. Cook.
Yes, Your Honor. Briefly, Mr. Williams is residentially challenged. However, on the date of the incident, it's my understanding that he had just been released from Grady Hospital and that people saw him and were assisting him. And it's my understanding he was trying to communicate to the officer that all of the belongings on the sidewalk actually did not belong to him. Therefore, that's why he did not want to move the items. Obviously, he is unable to make the $600 surety bond. He is on a fixed income. It's my understanding he receives SSI. We are asking the court to either reduce the bond or give him an unsecured judicial release.
All right. At this time, defendant will receive $1,000 signature bond through the jail. and he's to stay away from the address on MLK Junior Drive and have no alcohol, drugs, or weapons. Is there anything further? All right, best of luck to you, sir. Now can Ms. Cook, all right, now can Ms. Cook, courtroom 3, and Miss the interpreter be placed in a breakout? And can we take the cases that do not belong to Ms. Cook?
Yes, ma'am.
Thank you.
We can go to position 3, Mr. Blackman.
All right, position 3, Mr. Blackman. Mr. Blackman, your case is 22 CR 008477Y. In this case, you're charged with loitering and prowling and criminal trespass with the offense date of December the 22nd. Do you understand your rights? Yes. All right, Mr. Howard.
32 total, 2 parole violations. I counted 3 FTAs. On probation in the cab for identity theft, fraud, possession of meth, burglary in the 2nd degree, theft by receiving, suspended license. He got an open ag assault. That was the last arrest. That's in the cab. You want more?
No, that's fine. All right, thank you. Whose case is this for the state? Ms. Brown, is it yours?
Yes, Judge.
All right, please proceed.
Second. Yes, Judge. On this day, officers responded to 1155 La Vista Road. This is the apartments, the Reserve at La Vista Walk. They got a call that someone was occupying a vacant residence without the permission or consent of the property manager, Ms. Jessica Houtart, there at the property. There was also another individual that was in the apartment with him, and that individual told police that he had been there to smoke some weed with Mr. Blackman. So that's where we get the loitering and the criminal trespass charge, Judge. Our recommendation is that the bond remain the same, which is a $5,000 surety bond, and that he stay away from the Reserve at La Vista Walk. Judge, primarily that recommendation is based on the criminal history that you've heard. He's obviously a flight risk, meaning that he has several FTAs, parole violations, probation violations. Also, he's a risk to reoffend, given the number of cases that he has and the open case that he has, Judge. And so we would just argue that he's not really a good candidate for bond, but since he's required to get one, we just ask that it remain the same.
All right, thank you. Ms. Hogue?
Yes, Your Honor. Mr. Blackman is 42 years old and he has lived in Georgia all of his life. He has significant ties here. He has a father in the metro area as well as a mother, aunts, and children. His income is spotty. It is on and off construction work. So as you know, especially with the colder temperatures, that tends to be lower this time of year than higher. So it does make living much harder. He did graduate from LaGrange High School, though he has not done any college since then. As I said, he's pretty much done on and off construction work for most of his life. Having read the warrants on this and having listened to the prosecution, I will question that these are still duplicate. The fact that there's a hearsay testimony of someone who's staying there that he's there to smoke weed doesn't mean that it changes to a loitering and a trespass. I do believe these are duplicate charges. So I would request that one of them be a signature bond through the jail and that the remaining criminal trespass charge be reduced to $1,000 surety bond.
All right, thank you. At this time, defendant will receive a $1,500 surety bond, $500 for the loitering and prowling, and $1,000 for the criminal trespass. He's to stay away from the address on La Vista Road and have no alcohol, drugs, or weapons as a condition of that surety bond. Is there anything further?
Nothing from the defense, Your Honor.
All right, thank you. Hearing none. Best
Your
of luck
Honor.
to you. Yes.
I'd just like to state that this is a co-defendant case with position 25, just so that you're familiar with the facts when we get there.
Okay. Okay, thank you. I'll try to remember that. You may have to remind me again, Ms. Mitchell. All right.
Will do.
Position 5, Mr. Caver.
All right, good afternoon, Mr. Caver. Your case is 22 CR008479G. In this case, you're charged with 2 counts of transmitting a false report of fire with the offense date of December the 19th and the 21st. Do you understand your rights?
Yeah.
All right, Mr. Howard.
20 total. All of his history come out of Alabama. Last arrest was 2016 probation violation. 2016 obstruction that was dismissed. 2011 obstruction. Another 2011 obstruction. Another 2011 arrest. Theft of property. Dangerous drugs. 2010 probation.
That's good. That's
All
good. Thank you. All right, Ms. Brown.
Yes, Judge. On this day, officers responded to fire alarm. The fire department responded to fire alarm being pulled. And while out there, that's at the at the rental car center at the Hartsfield-Jackson International Airport. While out there and investigating, they also found out that there had been another incident where the fire alarm had been pulled. They pulled the video from the 1219 incident and was able to identify Mr. Caver from that incident. And so that's where he gets the second charge of pulling a fire alarm. Judge, very dangerous for him to pull a fire alarm in a very busy place. The bond is currently $4,000 surety. We were asked that it remain the same. In addition to that, just being just a very dangerous act and someone could have been hurt. Also, given that he is at this point a flight risk, also that he has numerous cycles that indicates that he's also at risk to commit further felonies, Judge. So we were asked that the bond remain the same.
All right, thank you. Ms. Hogue.
Yes, Your Honor. Mr. Caver is, Mr. Caver is 53 years old, Your Honor, and I would like to note that he's been given a history. The history hearing, the most recent is 2016, of which the charge ultimately was null pros, and we're going then back another 5 years for obstructions and theft. So I'm not really hearing anything felony or anything else in here, especially nothing recent within, say, the last 10 to 12 years. Just to let you know, he is not a flight risk, Your Honor. At this point in time, though, it does sound like he has a lot out of Alabama, and he does have his high school degree out of Alabama. Mr. Caver has moved here because he's been in a relationship with his girlfriend for over 2 years. He's moved here to be with her. He's been here and is definitely moving here to live here and to be with her. Not only that, but he has grandchildren and everything else that he has bought gifts for that also live in Georgia. So at this point in time, he is not a risk at all. In fact, he has significant reason to be here and to be staying here. He has grandchildren here. He has a girlfriend here that he came here to make a life with. I do understand that the way this worked is that they got the alarm. There was nothing showing that he touched it on the most recent time, but then they looked at something from 2019 that they believe that he did in fact do something, and then kind of cobbled it together to assume, based on seeing him in a stairwell, that he also did the more recent one. So there isn't even an actual direct video of him even doing this most recent one, and questionable about the other one. So, Your Honor, I do believe that despite he has cycles, they're old. He is not a flight risk, and it's even questionable as to whether or not he committed the most recent one, that signature bonds are warranted in this case. And if not absent a signature bond, I do believe $500 per charge is more than ample to assure he shows up in court to address these issues.
Judge, if I may really quickly.
Very briefly.
Just briefly, Judge, I just want to make a correction on that. They did see him in the video on the 1219, and when they spoke to him about it, he did acknowledge pulling it on both occasions. He did attempt to provide an explanation, but he did acknowledge it, Judge. That's it for the state.
All right, defendant will receive a $2,000 split bond. It's going to be $1,000 signature bond through the jail on count 1 and $1,000 surety on count 2. Was the state requesting a stay away?
Yes, Judge, a stay away. I'm not sure if he's employed, so a stay away unless he's employed and can return.
A stay away from that location unless he is employed there. If he's employed there, he may return, and he's to have no alcohol, drugs, or weapons. Is there anything further?
Nothing from the defense, Your Honor.
All right. Best of luck to you, sir. Can we move to the next position, please?
Position 6. Mr.
All
Chair.
right. All right, we'll now go to Mr. Chafin. Your case is 22 CR 008466J. In this case, you're charged with battery, family violence, and criminal trespass with the offense date of August the 22nd of 2021. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
He was arrested on the 22nd for a window tint, but I guess he had an outstanding warrant, so that's why he went to the city jail for that. 2013 out of Tennessee, disregarding red light, reckless driving, and a 2009 failure to appear. That's it.
Okay, thank you. Ms. Brown?
Yes, Judge. On this case, on the 22nd of 2021, the defendant cut the victim with a knife that left a bruise, causing him to bleed. The defendant also told the victim he was going to end him. The victim name is Mr. Childs, that he was going to end him. Once that happened, the victim ran to his car, and then the defendant came out and stabbed his tire. The victim indicated that they have been living together for approximately 5 years. We are asking for a $7,000 bond on this, $5,000 on the battery, $2,000 on the criminal trespass, surety bond, a stay away from the residence, no further contact with Mr. Childs, no alcohol, drugs, or weapons, Judge. As we've heard, I mean, he doesn't have a significant criminal history, but the allegations in this case are very serious. Anytime someone is pulling a knife in a domestic situation and causing someone to cutting someone with a knife, and then also threatening him, and then chasing after him and stabbing his tire, Judge, I think it warrants a significantly higher bond. And so that's why we're asking for the $7,000 surety.
All right, I am going to sound for Mr. Childs at this time. If Mr. Childs is present on the Zoom conference and wishes to be heard. All right, hearing none. Ms. Hogue?
Yes, Your Honor. Mr. Chafin is 35 years old, Your Honor, and he has significant ties here. He's been here for a number of years. He has family here, mother, brother, sister, friends. He's unemployed, but he is currently going to be starting a job back with a company that he worked for 9 years, Global Financial, doing underwriting. And he's, like I said, he's been there. He has a high school degree, but he did not go on further to college. And I would like to clarify several things here. Number one, as you can see, this charge is over a year old. Mr. Childs and he were in a relationship at the time. Okay. This was not reported for several days until several days afterwards. Mr. Childs went back wanting to not go forward with this. He and Mr. Childs are no longer together as a couple. However, they do have contact, friendly contact, probably phone calls about once a month. They are in good stead. Mr. Chafin soundly denies all of these, okay, all of this issue whatsoever. This is obviously a relationship that was ending, so there's a lot of back and forth, I'm sure. Given the age that this is, the fact that Mr. Chafin wasn't even aware of these charges, and he and Mr. Childs have been in communication since then. They are no longer together, but they are friends. They do communicate. He has no problem with the no contact because they don't live together, but also it's no problem with contact as well. Mr. Childs does not want to go forward. In fact, has tried to get the charges dropped. And given the fact that he's been unemployed and will not start work for a while, we do believe, given his limited history with no violence in it other than the reckless driving, and that his aunt died, and there's a funeral tomorrow, and also his family he has Christmas with. We are asking for a signature bond here. We do not think it's all that unrealistic at all, given his lack of criminal history, the time since this has happened, the fact that he and Mr. Childs have been in contact, but are no longer together, and his family situation as well. So we do believe that a signature bond is warranted here.
All right. At this time, defendant's going to receive a $2,500 split bond. It'll be $1,500 surety for the count 1 battery, family violence, and 1,000 signature through the jail for the criminal trespass. He's to have no contact with Mr. Childs and have no alcohol, drugs, or weapons. Was the state requesting a stay away? Was there a stay away address? I apologize, Ms. Brown, if there was. I didn't hear one.
Well, there is a stay away from the residence.
Okay.
6804 Sterling Drive.
Okay. In light of the age of this case, Ms. Hogue, I want to make sure that's not his home. Is that his home?
Not that I'm aware of, Your Honor. I don't believe so. I
Okay.
don't believe anyone's living there, or neither of them are living there at this time.
Okay, so we will, I believe the no further contact will address that. All right, best of luck to you, Mr. Chafin. Who do we have next?
Position 7, Mr. Collins.
All right, good afternoon, sir. Your case is 22 CR 0084838H. In this case, you're charged with battery, family violence, and simple battery, family violence with the offense date of December the 23rd. You understand your rights?
I do.
All right, thank you. Mr. Howard, can I have back history, please?
First.
Oh, first. You're right. I didn't have that. All right, Ms. Brown, we'll go straight to you.
Yes, Judge. Officers responded to this incident, and this is a dual arrest case, Judge. The other person arrested is Stella Dacunha. When they responded out to the location and they spoke with Mr. Colon, when they spoke with Ms. Dacunha, Dacunha, she told the police that she had been in a physical dispute with Mr. Colon, that they got in a dispute over a Wells Fargo bank account, and he became aggressive, snatched her phone, and in the process of snatching her phone and them struggling over the phone, she received an abrasion to her middle finger. She also received a scratch to her lower leg, and she also advised the police that he choked her in the process of that struggle. Officers asked her more about that. She indicated that she never lost consciousness, but he did in fact choke her. And so that's the basis of the charges against him. The recommendation is a $3,500 surety bond. A no further contact was Stella Dacunha, and a stay away from the location.
Okay, is it alleged that they both live there together? I'm assuming so.
Yes.
Okay. And Ms. Hope, do you must not represent the cross defendant. Ms. McLeod, you represent Ms. Dacunha? Is Ms. McLeod here? Does Ms. McLeod represent position 12?
Yes, she does.
She does. Okay. We'll have to figure out the residence part. Go ahead, Ms. Hope, please proceed.
Thank you, Your Honor. Mr. Cohen is 39 years old, Your Honor. He's lived in here for all of his life. He has significant ties here. He's lived here for 4 years, and he has significant ties here. He right now lives with her as well with his son, Max, 6 years of age. The address is his, not hers, and he lives there with his son as well. So if there has to be a split apart, Your Honor, it would be that she would need to leave, because that's where he has and lives with his son, Max, whom then he also shares joint custody with Max's mother, Laura. He has a high school degree as well as a BA in aerospace from San Diego, as well as a culinary degree. He, as I said, he has been here for 4 years. He has come here to be with Miss Stella, who's been in a relationship with. He works with the Fifth Group restaurant that he's worked there for now 15 years. He has significant ties here. He has a significant job here. He has a child, so he is not a flight risk. So we do believe that he has no criminal history whatsoever. So we do believe a signature bond is warranted here. He understands that there may be a no contact. If that's the case, then she would need to move, as that is his residence with his child, Your Honor. So we do believe, like we said, that signature is warranted in this case.
All right. At this time, defendant will receive a $3,500 signature bond through pretrial services, broken down 2,000 count 1, 1,500 count 2. He is to take a 1-day anger awareness course, have no contact with the cross defendant, and have no alcohol, drugs, or weapons as a condition. Is there anything further?
For Judge.
For Judge.
Your Honor, if I could just chime in briefly, we're going to be
Yes.
asking that the female defendant be allowed to return. She also is a resident of the home, and his case is actually under review of the DA's office, because it seems as though he may have been the primary aggressor, seeing how he strangled her. So we're going to be asking for a stay away. She also is a resident, and she will need somewhere to stay as well.
Wait,
Your Honor,
to clarify, hold on, Mr. Walker. Are you saying that the residence is hers?
I'm saying that she's lived there for more than 30 days under Georgia law that considers her to be a tenant and a resident at the resident. irrespective to whose name is on the lease.
Right,
She's
I
resided there more than
understand.
30 days. So because his case is under felony review, we are asking him to stay away from the address and allowing the female defendant to return.
Your Honor, his son stays with him. So you're asking him and his son to move out. I do
didn't
believe
mention
it's
his
more
son's. I
appropriate
didn't
for
mention
her.
his son's. I didn't mention his son's name. I mentioned him. I'm asking him to stay away from the residence that he shares with her.
The son is not hers.
Ms. Hope, 1 second. If we were to grant this stay away, is there any other place defendant could stay?
No, Your Honor, this is his resident with his son.
Your
His
Honor,
son is not, Miss Stella is not the co-defendant's son, it's his son.
Okay, 1 second.
I'm not
Ms.
mentioning his
McLeod,
son.
Your Honor, I
Mr. Walker,
represent-
1 second, Ms. Walker, Ms. McLeod, yes?
I represent the cross-defendant, Your Honor, and I
Alright.
have spoken with her. She tells me that she can stay with her mom.
Okay, so we're gonna leave it as is. He can return to his home, and we're gonna allow the cross defendant to stay away from that address. All right, thank you for that point of clarification, Ms. McLeod.
You're welcome, Your Honor.
All right, does that conclude Mr. Kalan's case? It does. All right, best of luck to you, sir. Can we take the cross defendant case now? Is that possible? Or no?
What position is that?
Stella DeCoon, I don't know what position.
Position 12, is that possible?
Oh, what's going on?
I
I
believe
see.
she's
Is
in
anyone else seeing a glitch in the Zoom?
Yeah, I see yours.
Yes,
Well, yeah,
Your
because it
Honor,
got
I'm seeing
McLeod.
it.
Man.
Okay,
We can still hear you though.
you can't, can you see me?
Well, yeah. I mean, it's you and Brown. It's going from screen to screen, but we can hear you, so we good.
and see you.
Okay, as long as we can. All right, I was questioning whether or not we could take Stella DeCunha's position.
They are in courtroom 3, but they having a
Oh,
breakout.
they're having that breakout. Okay, that's fine. All right, who do we have next?
Position 9, Mr.
All right, good afternoon, Mr. Coppage. Your case is 22 CR 008481A. In this case, you're charged with simple battery, family violence, 2 counts with the offense date of January the 11th. Do you understand your rights?
Yeah.
All right, Mr. Howard.
11 total. Last was 2019, simple battery, family violence, misdemeanor possession of marijuana. 2018, obstruction. 2015, he had an ag assault. It was amended to pointing pistol at another, 2 counts. That was a conviction.
Okay.
2014, theft by taking, probation violation. Came off a 2013 arrest. 2012, obstruction, 2 counts, preventing or disrupting law meetings or gatherings, conviction. That's
Okay.
it.
Thank you. All right, Ms. Brown.
Yes, Judge, on this case in January, is it January 11th? January 1st, Officer Jones arrived at 469 Marietta Street. He met with Brittany Hopkins, the victim, who indicated that her son's father, Mr. Christopher Coppage, assaulted her. When she was getting ready for work, he accused her of going to meet another guy. He grabbed her right arm, pushed her into the wall. As she attempted to leave, he punched her in the right face. There was a witness that heard the commotion, heard Ms. Hopkins scream, "Get off of me," opened the door and saw the defendant on top of Ms. Hopkins punching her. The recommendation in this case is a $6,000 surety bond, $3,000 per count, no further contact with Brittany Hopkins, day of anger management, no alcohol, drugs, or weapons. Judge, the basis for it obviously is the seriousness of the charge. In addition to his criminal history, there's quite a bit of violence in his criminal history. Although the ag assault was reduced, there was a pointing a pistol at another. There was a battery charge conviction from 2013. There was the obstruction from 2018, the obstruction from 2013, Judge. And so we have serious concerns about our victim in this case. Also that he is also at risk to commit further offenses in this case, Judge. So we would just ask for that $6,000 surety.
All right, I see Ms. Hopkins on the line. Ms. Hopkins, if you'd like to make a statement, I need you to unmute your screen and I need to place you under oath Would you like to make a statement?
Yes.
Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, the court is most concerned with whether you'd like to have contact with the defendant. What would you like to tell me at this time?
Yes, I would like to have. Yes, I would like to have contact with the defendant.
All right, is there anything else you'd like to let me know?
We got an apartment together, and these two right here together, and we don't fight or argue no more. We've been in the apartment since April, and
Okay.
everything's been going well.
All right, thank you. Ms. McLeod?
Yes, Your Honor, my client is 28 years old. He and Miss Hopkins share two children, two sons, a 5-year-old and a 1-year-old. This incident happened approximately a year ago, Your Honor. It was the 11th of January that this happened. And at the time, my client and Miss Hopkins were in a really bad place. They were homeless. They were living in a shelter. So things were very strained between them. The incident happened there. Since then, they have straightened things out. They've gotten their lives together. They have an apartment together and have been raising these two boys together. I had the opportunity to speak with Miss Hopkins earlier today, and she tells me that they are in a really good place now. And as she testified to the court, they haven't had any issues at all. Both of them are trying to get back to school so they can do better for their boys. And they tell me they're also trying to go to church and sort of trying to get their life together. I understand this is a year old, Your Honor, and they've been living together since with no issues. I understand that my client does have a bit of a history, Your Honor, but it is old. He doesn't have anything open, and things are going well between them. So I would ask the court to give him a signature bond so he can get home to help Miss Hopkins with the boys, and that he can also get back to work, Your Honor, to help out with his family. Nothing further.
All right. At this time, defendant will receive a $5,000 surety bond, $250 on each charge. He is have no further violent contact with the victim, last name Hopkins, and have no alcohol, drugs, or weapons. Is there anything further?
Nothing
All right.
further.
All right, hearing none. Best of luck to you, sir. Who do we have next?
Position 10, Mr. Crawford.
All
And
right.
after position 10, we're ready for the two interpreter cases, please.
All right, thank you. Mr. Crawford, your case is 22 CR 00842F. In this case, you're charged with criminal trespass with the offense date of December the 23rd. Do you understand your rights?
Yes.
All right, Mr. Hart, can I have the history, please?
19 total. Last arrest was 2020 for trespass. He got time served for that. 2018 probation, theft of lost mislaid property, criminal trespass. Disorderly conduct conviction 2017. 2017 failure to appear and a probation violation. 2016 FTA. 2015 the trespass and theft conviction. 2015 FTA theft by receiving. 2014 shoplifting. 2014 probation.
That's good. Thank you. Ms. Brown?
Yes, Judge. On the 23rd of December, Mr. Crawford, officers respond to 985 Howell Place, Southwest Atlanta, Fulton County. It spoke with Ms. Tercia, Tercia Kindred, Kindred, who indicated that Mr. Crawford, without her consent, was unlawfully occupying the property in the in the back part of her property, using a self-made tent. The bond right now is currently $1,000 surety. We're just asking that that bond remain the same, given that he has at least 3 prior criminal trespasses, 2 FTAs, several VOPs, and so that he's definitely a flight risk, a concern not to return to court. And so we would just ask the court to leave the bond as is.
All right, thank you. Who represents this defendant?
I do, Your Honor, Ms. Hogue.
All right, Ms. Hogg, please proceed.
Yes, Your Honor, Mr. Crawford is 42 years old, Your Honor. He's been in Georgia since 2007. That puts him here for at least 12, 14, 15 years. He recently moved to Nashville. That's why it appears, but he does have a stable address in Nashville as well as he has family here. Mr. Crawford is what we call an urban farmer in a way. What he does is he renovates spots or places in the urban areas for vegetable gardens and things of that nature. The property we're talking about is one that's in dispute, and it's got a civil suit against it for work that's been done there by Mr. Crawford for the fact that it's been abandoned property for some time where he was working with it. So, Your Honor, there is a potential civil suit going on here and dispute over the ownership of the property and whether or not it was an abandoned property to begin with. So at this point, I do recognize that he does have a history, Your Honor, but it is not a violent history that I can see. It does have trespasses, but given that there is a question as to ownership of the property to begin with, we would say I would like a signature bond if possible. If not, reduce it to a $500 good bond, Your Honor, and that's all we're requesting.
All right, thank you. At this time, the bond will remain set at the $1,000 surety, and he is to stay away from the incident location. Is there any thing further?
No, Judge.
No.
All right, thank you. All right, at this time, we will go to the interpreter cases. Which position do we are requiring interpretation?
$16 and $23, Your Honor.
All right, thank you. Who is before me at courtroom 3?
Say your name.
¿Quién?
Look.
Diga su nombre, por favor.
Julián Camilo Flores Stapper.
Julián Camilo Flores Stapper.
All right, good afternoon, sir. Your case is 22 CR 008468F. And in that case, you're charged with battery family violence and simple battery family violence.
Señor, su número de caso es 22CR008468, en el cual tiene 2 cargos en su contra por golpes y lesiones, violencia familiar, y por golpes y lesiones simples, violencia familiar.
And this was it's alleged to have occurred on December the 20th of 2022.
Y está alegado que ocurrió el 20 de diciembre del 2022.
You have an absolute right to remain silent. Anything you say can and will be used against you.
Usted tiene el derecho a guardar silencio y todo lo que diga puede y será usado en su contra.
You also have a right to an attorney.
También tiene derecho a tener un abogado.
This proceeding is broadcast over the internet. It's also being recorded.
Este proceso está siendo publicado en la internet y también está siendo grabado.
That means any member of the public can watch this.
Quiere decir que todo miembro del público puede observar esto.
Do you understand your rights?
¿Usted entiende sus derechos?
He's muted. Just nod yes. All
Señor,
right.
he's mute. Okay.
Okay,
Señora.
Mr.
¿Lo
Hart.
entendió?
First arrest.
All right, first arrest.
Le preguntaron al señor Hart, este es su primer arresto.
All right, since this is first arrest, we will go straight to the state.
Como es el primer arresto, vamos a dejar que hable la fiscalía.
Whose case is this? Is it Ms. Brown?
¿De quién es este caso, la señora Brown?
Yes, I apologize, Judge.
Sí, disculpas.
Judge, in this case, officers were in the area of 1155 Joseph Boone Boulevard.
En este caso, la policía estuvo en el domicilio de 1155 Joseph E. Boone Boulevard.
When they heard some screaming and came into contact with Betsy Johanna Morantes Galvez.
One moment, please. Johanna Morales Galvez.
Morantes, Morantes, Galvez, Galvis.
Thank you, madam. Ellos escucharon gritos y se contactaron con Betsy Johanna Morantes Galvez.
She indicated that she's the sister-in-law of the defendant.
Y ella indicó que es la cuñada del acusado.
She told the officer that he had punched her on the left side of her face and pulled her by her hair.
Ella le dijo a los policías que él le dio un bofetazo en la parte izquierda de la cara y le tironeó el cabello.
She attempted to leave the apartment and the defendant ran after her.
Ella intentó salir del departamento, pero el acusado la siguió.
The officer noticed that she had scratches to the right side of her face.
El oficial de policía notó que tenía rasguños en el lado derecho de su cara.
And she told the officer she received those scratches when he attempted to grab her through the fence.
Y ella le dijo a los policías que ella recibió esos rasguñones cuando trató de agarrarla de nuevo.
She also told the officer that they do live in the apartment together.
Y también le informó a la policía que viven juntos en el departamento.
The recommendation in this case is a $5,000 surety, $2,500 per count.
Lo que se recomienda como fianza es un total de $5,000 para una fianza de garantía, serían $2,500 por cargo.
No further contact with Ms. Galvez.
Y no tener ningún contacto alguno con la señora Galvez.
No alcohol, drugs, or weapons.
Y queda prohibido el uso de drogas, alcohol y armas.
All right, thank you, Ms. Brown.
Gracias.
All right, I'm sounding for Ms. Galvez. If Ms. Galvez is on the line and wishes to be heard.
Señora Galvez, ¿está presente en la plataforma? ¿Quiere que se le escuche?
All right, hearing none, we'll go to Ms. Cook.
Thank
Señora
you,
Cook.
Your Honor. Mr. Flores is 30 years old. He's currently employed at Hilton Hotel in the housekeeping department.
El señor, mi cliente tiene 30 años de edad y está trabajando para el Hotel Hilton en la parte de limpieza.
He's a college graduate.
Él se graduó de la universidad.
He has been in a long-term relationship, basically common law, to his wife, who's made
I'm sorry. Go ahead.
alternate arrangements for them to live elsewhere.
Él ha tenido una larga relación de vivir juntos con su esposa y también está preparado para hacer arreglos de vivir en un domicilio alternativo.
As far as the facts in this case, Mr. Flores maintains that he is innocent.
El señor Flores mantiene que es inocente basado en los hechos de este caso.
Without getting too much into the details, it's my understanding that he was actually breaking up a dispute between his brother and his sister-in-law, the complaining witness.
Sin irme con detalles, él explica que él estaba tratando de separar en una pelea entre su hermano y su cuñada.
We are asking the court, as this is Mr. Flores' first arrest,
Debido a que este es el primer arresto del señor Flores, le pedimos a su señoría
for him to be released on an unsecured judicial release.
I'm sorry, in a what?
A signature bond.
Oh, okay, thank you. Le pedimos a su señoría que considere otorgar una fianza no monetaria bajo firma.
If the court is not inclined to do that,
si el juez la jueza no quiere eso,
we're asking for a max of $500 on each count.
Pedimos que se le otorgue una fianza de $500 en cada cargo como máximo.
Nothing further.
Nada más de parte de la defensa.
I need to clarify one point. The alleged victim is his alleged wife or girlfriend?
Por favor, si pueden clarificar, ¿la víctima es su esposa, no?
His sister-in-law.
Es la cuñada.
His brother's wife.
Es la esposa de su hermano.
All right, and is he alleged to live, the sister-in-law lives in the same home where he resides?
¿La cuñada vive ahí en el mismo lugar donde él vive? Sí.
Yes.
All right, understanding now. All right, at this time, defendant will receive a $5,000 signature bond per judge through pretrial.
En este caso, el acusado recibe una fianza no monetaria bajo firma de $5,000 a través de los servicios previos al juicio.
That's $2,500 on each count.
$2,500 por cargo.
He is take the 1-day anger awareness course.
Él tiene que tomar una clase de control de la ira.
And he is to have no further contact with the alleged victim.
Él no puede tener más contacto con la alegada víctima.
He must stay away from the address.
Él debe mantenerse alejado de esa dirección.
The incident location.
Donde,
And
donde ocurrió el accidente.
he can return one time with a member of law enforcement to get any items.
Él puede regresar solamente una vez con un oficial de policía para retirar todas sus pertenencias personales.
And he's to have no alcohol, drugs, or weapons.
Y queda prohibido para él el uso de drogas, alcohol y armas.
Is there anything further from either party?
¿Algo más de alguna de las partes?
Judge,
Thank you.
Judge, that address, I believe, is 1155 Joseph Boone Boulevard, but nothing from the state.
Creo que el domicilio es 1155 Joseph E. Bone Boulevard.
Hey, let him know he gonna have to report the pretrial for orientation.
Por favor, avísenle que él va a tener que presentarse ante la Oficina de Servicios Previos al Juicio para recibir la clase de orientación.
And they'll give him the instructions before he leaves, which are in English, but
Y le van a dar las instrucciones para hacer esto, pero por supuesto, estarán en inglés.
they'll probably have an interpreter for the orientation on Zoom.
Pero probablemente van a tener un intérprete a través de Zoom para que realice la orientación.
Your Honor,
Okay.
that's problematic if he can't read in English. Would somebody be able to tell him?
Es un problema de si no puede leer inglés.
Well, the orientation will have an interpreter.
Durante la orientación vamos a tener un intérprete.
And I don't know what the date gonna be, so it's gonna be on the sheet that he gets before he gets released.
La fecha no la tenemos, pero va a estar en esa hoja de instrucciones que él va a recibir.
All right. Have we concluded all matters that pertain to this case?
Muy bien, terminamos con este caso.
Yes,
Sí, su
sir.
señoría. Sí, su señoría.
Best of luck to you, Mr. Flores. Who
La
do we have
mejor
next?
suerte. ¿Quién es el próximo?
Position,
Sánchez Martínez, I believe.
position 23, Sanchez.
No, we have one more interpreter case in courtroom number 3, please.
I know it. It's 23, Sanchez.
Thank you. Both. All right. Good afternoon, Mr. Sanchez.
Buenas tardes, señor Sánchez.
Buenas tardes.
Your case is 22 CR 008463B, and you're charged with battery family violence.
Su número de caso es 22CR008463B y usted tiene un cargo por golpes y lesiones, violencia familiar.
This case is alleged to have occurred on November the 22nd of 2022.
Este incidente se alega que ocurrió el 22 de noviembre del 2022.
You have an absolute right to remain silent. Anything you say can and will be used against you.
Usted tiene un absoluto derecho a guardar silencio porque todo lo que diga puede y será usado en su contra.
You have a right to an attorney today.
Y también tiene derecho a tener un abogado hoy.
And this proceeding is being broadcast over the internet as a live stream. It's also being recorded.
Esta audiencia se está publicando en la internet y también se está grabando.
That means any member of the public can watch this.
Quiere decir que todo miembro del público puede mirarla.
Do you understand your rights?
Usted entiende sus derechos. He's muted, Your Honor.
All right, thank you, Mr. Howard.
You got 8 total.
En 8 en total.
Last arrest was in November for battery. That was out of Fayetteville.
El último arresto fue en noviembre debido a golpes y lesiones en Fayetteville.
2020 and 2021 DUI conviction.
Y tiene un cargo por manejar bajo los efectos del alcohol en el 2020 y el 2021.
2012 probation and driving without a valid license conviction.
Y en el 2012, probatoria por manejar sin licencia.
And in 2012, he was arrested by ICE for alien inadmissibility. That's it.
Y por inadmisibilidad de no residente en el 2012 también, por inmigración.
All right, thank you. Ms. Mitchell?
Gracias, señora Mitchell.
Yes, Your Honor, in this case, the defendant battered the mother of his 3 children, Miss Rosario Garcia,
En este caso, su señoría, el acusado golpeó a la madre de sus 3 hijos, Rosario García,
by punching her in the face.
al darle un bofetazo en la cara.
Miss Garcia stated that while at the Mexican market, the defendant threw away her coffee and a verbal dispute began.
La señora García dice que en el mercado mexicano, el acusado tiró un café, el café que tenía en una taza como parte de la disputa entre ellos.
Defendant got angry and started punching her repeatedly in the face.
El acusado se enojó y comenzó a bofetearla repetidamente en la cara.
This left her with lacerations and bruising to her face and arms.
Esto la dejó con rasguños y moretones en la cara y en los brazos.
The victim struck him with a glass beer bottle on his hand in self-defense.
Y la víctima lo golpeó con una botella de cerveza en la mano para autodefenderse.
Your Honor, there's a current $10,000 surety bond on this case.
Hay una fianza actual de bajo garantía de $10,000 en este caso.
And the state requested that bond remain the same.
Y la fiscalía solicita que se mantenga igual.
With no further contact with the victim, a stay away from the incident location, 1-day anger awareness, and no alcohol, drugs, and weapons.
La fiscalía solicita que no tener más contacto con la víctima, que se mantenga alejado del lugar del incidente, que tome una clase de control de la ira y que quede prohibido el uso de drogas, alcohol y armas.
The defendant's open battery family violence case in Fayetteville is with the same victim.
El caso que está pendiente por golpes y lesiones, violencia familiar, se trata con la misma víctima en Fayetteville.
Along with the risk of reoffense, the state's also concerned that defendant is a flight risk.
Nosotros, la fiscalía tiene la preocupación de que este acusado vuelva a cometer el mismo delito y que también intente huir.
The defendant already has history with ICE, and we're concerned that he will flee to avoid consequences of his actions that could lead to his deportation.
Este acusado ya tiene un historial con el Departamento de Inmigraciones, lo que puede causar que él trate de huir para no enfrentar las consecuencias y ser deportado.
Our victim advocate also had an opportunity to speak with Ms. Garcia.
Nuestra defensora de víctima también pudo hablar con la señora García.
And she states that her and the defendant have a domestic violence history.
Y ella declaró que ella y el acusado ya tienen un historial de violencia doméstica.
But she's never called the police because she's in fear of him.
Pero nunca llamó a la policía antes porque ella le teme a él.
She stated that the defendant can be very aggressive and gets very jealous.
Ella declaró que el acusado...
Yeah, I'm going to object some of this, as I believe that at this point it's outside the purposes of what we're here for.
Objeción, creo que esto está fuera de los límites de los temas que podemos hablar.
I'll allow it. Please continue.
Yo lo pregunto. One moment, Your Honor, I didn't finish the
No, I'm sorry.
statement.
Go ahead. I apologize. Go ahead.
Thank you. víctima dijo que este acusado se vuelve agresivo y muy celoso. Thank you.
All right, I'm gonna allow it, but I ask that Ms. Mitchell keep it brief and limited. Go ahead.
Lo permito, pero quiero que la señora Mitchell haga una presentación breve.
And lastly, the victim was able to provide the medical form from the ambulance confirming her injuries. Nothing further, Your Honor.
Y finalmente la víctima pudo presentar una boleta médica debido a los servicios de la ambulancia y demostrando las consecuencias de sus lesiones.
All right, thank you, Ms. Mitchell.
Gracias, señora Mitchell.
All right, I'm gonna sound for Ms. Garcia at this time.
Voy a llamar a la señora García, está presente en la plataforma.
Ms. Garcia, if you're
Your Honor,
present.
she stated that she wasn't going to be present on this Zoom.
I'm
Ella
still gonna
dijo que no
sound,
estaría
just to be
presente.
sure. Ms. Garcia, if you're present, please unmute your screen. If not, we'll go to Ms. Cook.
Señora García, si está presente en la plataforma, por favor, prenda su micrófono, si no seguiremos con la señora Cook.
All right, hearing none, Ms. Cook, please proceed.
Señora Cook, por favor, proceda.
Thank you, Judge. Mr. Sanchez Martinez is 34 years old.
El señor Sánchez Martínez tiene 34 años de edad.
He's been in Georgia for the last 5 years.
Ha estado en Georgia por los últimos 5 años.
He's a high school graduate.
Él terminó su escuela secundaria.
He maintains his innocence in the present case.
Y él mantiene su inocencia en este caso presente.
We understand that the court is likely to issue a no further contact with the victim. He has no issues with that.
Vemos que la jueza tiene intenciones de no permitir el contacto con la víctima y él está de acuerdo con eso.
And additionally, he's able to live with his brother's house, who lives in Fayetteville, Georgia.
Y además, él está dispuesto a vivir con su hermano, en la casa de su hermano que vive en Fayetteville, Georgia.
As far as the bond amount, Your Honor, we're asking the court to reduce the bond. He works in the landscaping industry and is not making as much money this season. So we are asking the court to reduce the bond to $500 each count.
Le pedimos a su señoría que por favor pueda reducir la fianza. El acusado trabaja en la industria del paisajismo y no gana mucho dinero, sobre todo en esta temporada, y que la fianza pueda ser reducida a $500 por cargo.
He does have 3 children who he also supports as well.
Él también tiene 3 niños menores a los que mantiene.
Nothing further.
Nada más de la defensa.
All right, at this time, defendant will receive the $8,000 surety bond.
En este caso, el acusado recibe una fianza de $8,000 bajo garantía.
He is to have no contact with Rosario Garcia.
No debe tener más contacto con Rosario García.
And stay away from their shared address.
Y mantenerse alejado del domicilio que ellos comparten.
He can return one time with law enforcement to get any items.
Él puede regresar con un oficial de policía una sola vez para retirar sus pertenencias personales.
And furthermore, he's to have no alcohol, drugs, or weapons.
Y además, queda prohibido para él el uso de alcohol, drogas y armas.
Is there anything further from either party?
¿Hay algo más de alguno de los dos casos?
Una pregunta, y si en caso de que no gano completar los $8,000 de la fianza, ¿cuánto tiempo tendré que estar aquí?
I have a question. If I cannot gather the $8,000 money, how long do I have to stay here?
Your case, sir, will be reset to the state all-purpose calendar on January the 5th of 2022.
23.
I'm sorry, 2023, yes.
Thank you. Señor, su caso tendrá una audiencia por los casos estatales en el día 5 de enero del 2023.
I'm going to ask Ms. Cook to give you a call as well to explain how this works following this case, this hearing today.
Y le voy a pedir a la abogada Cook que lo llame para explicarle a usted cómo todo esto funciona una vez cerrado ahora este caso en este día.
Sí, está bien, gracias. De todo modo voy a hablar con mi abogado para ver si gasto de completar
That's
la
fine. Thank you very much. Anyway, I'm trying to talk to my attorney and see what I can do at the same time.
All right. Best of luck to you, sir. That concludes your case.
La mejor de la suerte, señor, y esto termina su caso. May the interpreter be dismissed, Your Honor?
Yes, will you sound one time to make sure no one else needs your assistance?
Absolutely. Buenas tardes. Si hay alguien, por favor, en la plataforma que necesita mi ayuda para ayudarle a hablar con la jueza, levante su mano y salude a la jueza, por favor. Is there
hearing
anybody
none?
waiting?
I don't think
Okay.
so. Hearing none. Enjoy the rest of your holiday.
Thank you. You too, and
for
Merry
logging
Christmas, Your
in.
Honor.
Merry Christmas. Take care. Bye-bye.
You too. Bye-bye.
All right. Who do we have next?
Position number 4, the private attorney case, please.
All right. Are you Donna Brown?
Yes, I am.
All right, Ms. Brown, your case is 22 CR 008478G. In this case, you're charged with battery family violence with the offense date of December the 21st. You understand your rights?
Yes, I do.
All right, Mr. Howard. Oh, first arrest. So we will go to Ms. Brown.
Yes, Judge. Officers responded to the residence and spoke with the victim in this case, Mr. Edward Brown, who is the husband of Ms. Brown. He indicated that she had found out that or caught him with another woman the day before, and he attempted to hug her, and she grabbed him in his private parts, caused him to bleed, caused a laceration. The recommendation in this case is a $3,500 surety bond, no further contact with Mr. Brown, and no alcohol, drugs, or weapons.
All right, is Mr. Brown on the line and wishes to be heard? I'm sounding for Mr. Brown. All right, hearing none. Ms. Rutledge, please proceed.
Good afternoon, Judge. Cherry Rutledge on behalf of Donna Brown. She is 56 years old. She has lived in the state of Georgia for 2 years, where she has a home with her husband. They also both live in New Jersey. She has her own home in New Jersey where she works for LabCorp, where she has worked for 30 years. She is a graduate of Camden Community College. She has plans to go back to New Jersey and to just get her personal belongings. She has no criminal history. There is a history of domestic violence. She currently has a temporary protection order against her husband, and we are requesting a signature bond. But in the alternative, if that is not allowed, $1,000, since she has no history, has been the victim, and they are currently in having a divorce proceeding in New Jersey.
All right,
Judge, if I may, real quickly, just very quickly. I would just ask for that surety bond.
I was going to accept the state's recommendation. Okay, so at this time, we accept the state's recommendation. It's going to be a $3,500 surety bond, and she's to have no further contact with Mr. Brown, and she's to further have no alcohol, drugs, or weapons. Is there anything further?
Is it okay if she returns to New Jersey? She plans to like to get her belongings and return to New Jersey in her home. He does not live there with her.
I'm not going to order that she can't do that. So, all right, as long as she is able to return to all court proceedings pertaining to this. All right.
Thank you, Judge.
All right. Best of luck to you, Ms. Brown. Ms. Rutledge, does that conclude your business before the court today?
Yes, Your Honor. May I be excused?
You may. Have a great holiday. Take care.
You too. Merry Christmas.
Okay. Bye-bye. Who do we have next?
Position number 2.
All right, good afternoon. Can you pronounce your first name for me, please?
Triana.
All right, Miss Detriana Barnett, your case is 22 CR 0084776B. In this case, you're charged with battery family violence, 2 counts, with the offense date of November the 14th of 2021. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
Second arrest. Last was 2021 theft by taking and obstruction. I think that's open.
Okay.
That's it.
Theft by taking. Okay. Thank you, Ms. Brown.
Yes, Judge. Officers responded to 112 Cortlandt Street in Atlanta and spoke with Mr. Gigger, Gigger, first name Lamont. He advised that he had been assaulted by Ms. Barnett. She is the mother of their son. She was staying with Mr. Gigger for a short period of time. She became upset when he told her to leave, and she scratched his face, and she also bit him on his right breast. The officer was able to see the bruising on his arm and also the bite mark on his right breast. State's asking for a $5,000 surety bond, $2,500 per count. No further contact with Mr. Lamont Gigger, and a stay away from the 112 Cortlandt Street, and no alcohol, drugs, or weapons.
All right, thank you, Ms. Hogue.
Yes, Your Honor. Ms. Barnett is 20 years old, Your Honor. She's been in Georgia all of her life. She has significant ties here, including her mother and her grandmother. She currently is working 2 jobs. She does temp work on one of them, so she's in the process of doing a switch. She was working for one temp situation, and now she's moving into working for Marriott, so there will be a lag in the money that she will be making as she switches over. And she also works at Clipper Petroleum as a cashier there at the gas station. So she is a very hard single mom, working very hard to support her child. Her son is 2. His name is Zaire, Your Honor. She also has a high school GED from UEI and is finishing up her medical assistant certificate at UEI. So she'll have that in 3 months to also further herself and get better jobs for her life in general. As you can see, this is over a year old, Your Honor, and she soundly and roundly denies all the charges. She obviously wasn't there when the officers came out. They do share a child, Your Honor, and they do co-parent as best as possible. So he does, they kind of switch, and he does pick up the child, and, she takes care of the child part of the time, he does too. So they are trying to work out a good co-parenting there. So she doesn't have a problem if it's going to be a third party. That's not a problem for her, and a no contact is not a problem for her. I'd like to point out that she has the only criminal history she has is a pending theft charge versus Mr. Giggers, who has a pending terroristic threats and stalking charge against another female that is now pending. So my client has no violence in her history. He now has harassing communications and stalking family violence against yet another female pending from 2021. We do believe that a signature bond in this case is warranted. She has significant ties, school, children, family, no history of violence, and only a potential, not even a conviction, a potential theft charge, Your Honor, versus Mr. Giggers, who has something more significant. So that is what we're asking at this time, Your Honor.
All right, thank you. At this time, defendant will receive a $4,000 signature bond through pretrial services per judge. She's take the 1-day anger awareness course, have no contact with Mr. Gigger. She can arrange to transport the children through a third party, and have no alcohol, drugs, or weapons. Is there anything further?
Nothing from the defense, Your Honor.
All right, best of luck to you, ma'am. Who do we have next?
Position number 12, Judge.
Judge, I'm sorry, there was no stay away on that last order, was there?
No. All right, this is the co-defendant case, correct? Stella DeCuna?
That's correct, Your Honor.
All right, what was the companion case? I apologize. It was position.
It was one Carlos Colon. I don't know what number.
Yeah, it was
Position 7. All
I
right,
think it was
it's
number
7.
7, I think.
Position 7. All right, good afternoon, ma'am. Your case is 22 CR 00848. I'm sorry, 22 CR 00848 In this case, you're charged with simple battery with the offense date of December the 23rd. Do you understand your rights?
Yes.
All right, thank you. This is first arrest. We'll go to Ms. Brown.
Yes, Judge. When the officers responded, they had spoken with Mr. Colon. They also spoke with Ms. DeCunha. And when they spoke with her, when they spoke with Mr. Colon about the incident, he advised similarly that there had been an argument over a Wells Fargo account and a physical altercation occurred. He told the officers that Ms. DeCunha made contact with him, that she pushed him, and she threw his phone to the floor so hard that it shattered the screen. The officer was able to observe the phone and looked at the phone and discovered that he had in fact attempted or there were attempted missed calls from Atlanta 911. I believe he had told them that he was attempting to call 911. And so that's a factual basis. The recommendation or request for bond is $2,500 surety, no further contact with Mr. Colon.
All right, and a stay away.
And a stay away from that location, yes, Judge.
All right, Ms. McLeod.
Yes, Your Honor, my client is 25 years old. She has an associate's degree and is gainfully employed as a pastry chef. She's been doing that now for approximately a year and a half. She denies that she was the aggressor in this incident, Your Honor. She has absolutely no record. As I mentioned earlier, she tells me that she does have another place that she can stay until this whole issue is resolved. She would prefer no further violent contact, Your Honor, because she tells me that she is not afraid of Mr. Colon. And this is just, a disagreement that they had. So I would ask the court to condition any bond that my client receives on no further violent contact with herself and Mr. Colon. Nothing further, Your Honor. And of course, I would ask that it be a signature bond since it's her first arrest.
All right, at this time, defendant will receive a $2,500 signature bond through the jail. She's to have no further contact with the cross defendant in this case and have no alcohol, drugs, or weapons. Is there anything further?
Nothing further,
Judge,
Your
say
Honor.
no further contact or no further violent contact?
I said no further contact.
Further contact. Okay.
And she must stay away from the location. She can return one time with a member of law enforcement to get any items. All right, is there anything further?
Nothing, Judge.
All right, best of luck to you, ma'am. Who do we have next?
Position 13, Mr. Dixon.
All right, good afternoon, Mr. Dixon. Your case is 22 CR 008469C. In this case, you're charged with battery with the offense date of December the 23rd. You understand your rights?
Yes, ma'am.
All right, it's the first, so we'll go to Ms. Brown.
Yes, Judge. Officer responded out to 1050 Howell Mill Road and spoke with the Sophia Tager, Tager. She told the officer that the defendant, Mr. Dixon, had battered her by leaving scratches on her neck that the officer was able to see. And that happened as he ripped her clothes off, Judge. The recommendation is $3,500 surety, no further contact with Sophia Tager, a stay away from the 1050 Howell Mill Road if that's not his address, and no alcohol, drugs, or weapons.
All right, thank you. I'm sounding for Ms. Tager or Taker. All right, hearing and seeing none, Ms. Hogue.
Yes, Your Honor. Mr. Dixon is 28 years old, Your Honor, and a practicing attorney. He has lived here in Georgia all of his life. He's from the Savannah area, where he graduated high school from Byron High School there in Savannah, as well as he graduated in 2016 from Southern Georgia as well as University of Georgia Law School in 2020. So he is a barred member, Your Honor. He's been working 2 years now, in the last 6 months for Clyde and Company, and before that, Denton. So he has significant ties here and significant reasons to clear this matter up. He soundly denies all these allegations, Your Honor, and he definitely intends to fight this without question. As far as the residents go, they do share the residence, but he has no problem moving out. He says he can temporarily move in with his mother until he finds yet another, place here in Atlanta. And he has no problem with a stay away, Your Honor. He has absolutely no criminal history. We do believe that a signature bond is justified in this case, Your Honor, especially since he is more than willing to be the party that will move out. He does ask for, basically, from talking to him, shall we say, 2 times to come in. Apparently, they both live together there. He's rented it, moved to here. And he knows that tonight he'd just like to be able to get back there very quickly so he can get clothing and things and spend Christmas with his family. However, there'll be a much larger, significant moving out that requires furniture and everything else that will in fact take time to arrange. So he is asking for essentially 2 times, one to go back there quickly tonight to pick up clothing and things so he can simply spend Christmas with his family reasonably. And then of course, in about a week or so when he can arrange for a more complete total move out. So that's what we're asking, Your Honor. We do believe a signature is more than warranted in this case.
Okay,
And Judge,
very quickly, Ms. Brown, go ahead.
my victim advocate has let me know that the victim may have already moved out of that location.
Okay. So here's what we'll do. Mr. Dixon is going to receive a $3,500 signature bond through pretrial per judge. He is to have no further contact with Miss Tager. Is that the last name? Tiger, Miss Tager?
Yes.
And what I'll do is, based upon the information received from the victim advocate, we will not put the stay away in place. Therefore, he can go and get whatever items he needs, but he can have absolutely no contact with her. So, Mr. Dixon, if you see her there, you just turn around and walk right back out. You can't have any contact with her at all. You understand that?
Yes, ma'am.
All right. I believe that concludes Mr. Dixon's case. Is there anything further?
Nothing from the defense, Your Honor.
All right. That's the luck to you, sir. Who do we have next?
Position 17, Mr. Gaddis.
All right. Good afternoon, Mr. Gaddis. Your case is 22 CR 008457A. You're charged with battery family violence with the offense date of December the 8th. Do you understand your rights?
I do, Your Honor.
All right, Mr. Howard.
15 total. He also has history out of Georgia and Illinois. He got 2 open cases.
Is one of the cases before me? Did he have a case before me? Are you able to see that?
Probably so.
Yes.
I mean,
Yes, Your Honor. They both
two
are.
open 2022 cases.
Okay,
The
I
victim was
remember
Terry
this.
Gaddis though, but
I
yeah.
remember this case. I remember this defendant. All right, go ahead, Mr. Howard.
I mean, I'll let the state take over. That's it. I just
Okay.
wanted you to know you had them 2 open battery deals.
Yeah, I believe there are 2 before me. All right, go ahead, Ms. Mitchell.
Yes, Your Honor. In this case, the defendant battered his daughter, Elise Gaddis, by grabbing her arms and pulling her out of her vehicle, leaving her with scratch marks on her right arm. Elise Gaddis stated that the defendant didn't say anything while he was pulling her out of the vehicle. He also pulled her by her hair to the ground. She also stated that the defendant took out a TPO on her, but he continues to make contact with her by coming to her residence. There was also a witness, Mr. David Przborski, spelled Pryzborski, who corroborated victim's testimony and stated that while he was sitting on his patio, he observed the defendant walking up to victim's vehicle, grabbing her by her arm and pulling her out of the vehicle and onto the ground. The witness also stated that this is an ongoing issue with domestic disputes at the Gaddis residence. Your Honor, as heard from pretrial, there are two open battery cases with his wife, which were before you. The one that occurred in November of this year, Your Honor gave him a $4,000 surety bond. That's the situation where he punched his wife. The simple battery family violence in August of this year, He dragged his wife on the ground, and Your Honor gave him a 2,500 surety bond in that case. In addition to that, he also has battery arrest in 2012, and simple battery and simple assault in 1992. Now, although that is old, I do believe it is relevant to show his violent nature. The state is recommending a $3,000 cash bond in this case, no further contact with the victim, Elise Gaddis. Stay away from the incident location, 2721 Hemingway Lane, Roswell, Georgia. 1-day anger awareness, and no alcohol, drugs, and weapons. Nothing further, Your Honor.
All right, thank you, Ms. McLeod.
Yes, Your Honor. My client is 57 years old. He is gainfully employed. He's an attorney, Your Honor, been practicing for over 33 years. He tells me that in this instance, what happened was that his daughter, who happens to be 24 years old, was very drunk, and he was merely trying to stop her from driving because she does operate a vehicle which is registered in his name, Your Honor, and she was about to go and drive this vehicle, and he was just trying to stop her from driving drunk. He did not assault her, Your Honor. He just wanted to prevent her from driving drunk, and that was all that was. He also tells me, Your Honor, that she was willing to come onto the Zoom to testify to all of that, but I wasn't able to get a hold of her, Your Honor. I don't know if she's on, but I was personally unable to speak with her. I would ask the court to give my client a signature bond, Your Honor, because in this case, all he was doing was trying to stop someone from driving drunk. It wasn't a situation where he assaulted his daughter. Nothing further, Your Honor.
All right, at this time, the defendant is going to receive an $8,000 surety bond. He's to have no contact with Ms. Gaddis, and he is to stay away from that incident location on Hemingway Lane, have no alcohol, drugs, or weapons as a condition. Is there anything further?
No, Your Honor.
Nothing further, Your Honor.
All right, best of luck to you, Mr. Gaddis.
Thank you.
Who do we have next?
Position 19, Mr. Hogan.
All right, good afternoon. Are you Kendrick Lamar Hogan?
Yeah.
All right, your case number is 22 CR 008459J. In this case, you're charged with 1 count of criminal trespass and 1 count of possession of marijuana less than an ounce, each with the offense date of December 22nd. You understand your rights?
Yeah, ma'am.
All right, Mr. Howard.
20 total. Last arrest was in July, probation for criminal trespass. Another July arrest, FTA trespass. February trespass dismissed. 2021 FTA trespass. 2021 criminal damage to property, 2nd degree. Obstruction. That's open. 22 SC 183501. April 2021 trespass. March 2021 disorderly conduct. Trespass pled NOLO 2 in 2020. Also has history out of Alabama. You want that history? Or that's enough?
No, that's sufficient. Miss Mitchell?
Yes, Your Honor. In this case, the defendant criminally trespassed onto the property of Miss Nada, spelled Nada, Massoud, spelled Massoud, located at 451 Haldane, spelled Haldane, Drive, Southwest, Atlanta, Georgia. Your Honor, he entered and remained in the vacant house without the owner's consent, even after being told the day before in the presence of an officer that he couldn't return to the property. Upon search incident to arrest, the defendant was found in possession of a plastic bag that contained less than an ounce of marijuana. Your Honor, the state's concern here is defendant's risk of reoffending. He did plead to criminal trespass in DeKalb this year. He also has 3 open cases, one of them being for criminal trespass. The open case, felony damage to property and obstruction, 2021, criminal trespass, 2021, and disorderly conduct in 2021. We also have concerns that he'll be a flight risk. He does have 2 FTAs, one in 2022 and one in 2021. With that being said, the state is recommending, as to count one, a $2,000 surety bond, and as to count two, a $500 surety bond totaling $2,500, a stay away from the incident location of 451 Haldane Drive Southwest, Atlanta, and no alcohol, drugs, and weapons. Nothing further, Your Honor.
All right, thank you. Is this your case? Sorry, Ms. Hogue?
This is
Oh,
Ms.
Ms. Cook. I
Yeah.
always get it wrong. Ms.
It's
Cook,
fine.
please proceed.
Mr. Hogan is 33 years old. He has 4 children, 2 of which reside with him here in Georgia. He's been in Georgia for about the last 4.5, almost 5 years. He's self-employed. He's a graduate of 2010 from Kentucky State University. He also has a trade in facility maintenance from Job Corps. He's self-employed, Your Honor. We are asking, and we do maintain that he's innocent of these particular charges, Your Honor. In fact, it's my understanding that the day prior, maybe he didn't fully understand the police's instructions, but it's my understanding that he was actually helping someone else move some belongings, and that's why he was there. And what else? It's my understanding that the day prior, what the police said was you can't come to this property unless you have a reason to be here, not to come back. So it's my understanding that when this does, and he's able to fight the charges for the criminal trespass, he would be able to present that he was actually helping someone move in that area. As far as count 2, possession of marijuana less than an ounce, Your Honor, we're asking that you definitely give him a signature bond on that case, as allegedly as marijuana, but obviously the state is not going to be able to proceed with that charge, or maybe even if you're inclined to dismiss it. As far as count 1, we're asking for the court to give him a $500 bond on that case. Thank you.
I'm sorry, Ms. Cook, what was the requested breakdown?
We're asking for a $500 bond total for count 1. Count 2, I'm not sure how you want to put it, but some sort of signature bond, nothing that he has to pay out of pocket because of the charge.
All right, thank you. At this time, defendant's going to receive a $1,000 split bond. It'll be $500 surety on count 1 and $500 signature through the jail. He's to stay away from that incident location on Haldane Drive and have no alcohol, drugs, or weapons. Is there anything further?
No, Your Honor.
All right, best of luck to you, Mr. Hogan. Who do we have next?
Position 20, Ms. McClendon. How y'all doing?
Right. All right, good afternoon. Your case number is 22 CR 008460Y. In this case, you're charged with a tag light violation, failure to obey signs, loitering and prowling, an open container, each with the offense date of December the 22nd. You understand your right?
Yes, ma'am, I do.
All right, thank you. Mr. Howard?
Get the rest. Last was 2019, unlawful for a jail inmate to possess controlled substance conviction. That was out of Douglas County. He should be on probation for that, based on the time. I got a burglary conviction from 2019 as well.
Okay.
He's on probation for that. 2016 theft by receiving. Unlawful eavesdropping. He got first offender for that in 2018. That's it.
Okay, thank you. Ms. Mitchell?
Yes, Your Honor. In this case, officers observed defendant driving with an inoperable tag light while traveling westbound on West Wesley Road at 3 a.m. While following the defendant, officers observed defendant make an illegal right turn where there was a sign that said no turn on red. The defendant continued to drive into a densely wooded area where a passenger in the vehicle jumped out and ran into the wood line. The defendant then continued to drive the vehicle until he reached the rear of a preschool and remained in his vehicle. Once officers caught up to conduct an investigation, he was placed under arrest, and they found an open bottle of Hennessy and La Gritona tequila that was recovered in defendant's vehicle within reach of the driver's seat. The defendant admitted to knowing about the bottles. Your Honor, the state's bond recommendation in this case is going to be $1,000 surety as to each charge, totaling a $4,000 surety bond. A stay away from the incident location, which is 2799 Northside Drive, Northwest Atlanta, Georgia, and no alcohol, drugs, and weapons. And Your Honor, that's going to be due to the allegations. In addition to his history, having several felony convictions, which all occurred in 2019, and we believe the gap is due to him being incarcerated. So with that being said, we are requesting a $4,000 surety bond. Nothing further, Your Honor.
All right, thank you. Ms. Cook?
Thank you, Your Honor. Mr. McClendon is 21 years old. We acknowledge that he does have a criminal past. However, we would assert that he has learned from his mistakes since being released from custody. He has been working 2 jobs as a security officer, unarmed security officer. He works for, I believe it's Nemo Security. He does works at Tiger, which is a club on Cobb, Marietta Parkway, and also at Chicken and Seafood Lounge. He's using that income to help his family. Although he does not have any biological children, he is married and his wife has children, and so he helps take care of her and her kids. With it being so close to Christmas, Your Honor, he is very tight on funds. He has been in Georgia all of his life. He is a high school graduate from Douglas County High School in 2018. We are asking the court to give Mr. McClendon a signature bond on these charges. We have no concerns that he's not going to come back to court to fight these allegations against him. He has been in Georgia all his life, no other ties anywhere else. Nothing further from the defense.
All right, defendant's going to receive a $3,500 split bond. It's going to be 1,000 signature on count 1, 1,000 signature on count 2, 500 surety count 3, and 1,000 surety count 4. Check my math, but I believe that's 3,500. And he's to have no alcohol, drugs, or weapons. And he's to stay away from the address on Northside Drive. Is there anything?
Yeah, how much is good?
1,500.
And how much is SOB jail?
2,000 SOB jail. All right, best of luck to you, Mr. McClendon. Who do we have next?
I got number 18 bonded out too. That's what I saw. Just so you know.
I'm sorry, Your Honor. I was stuck on the breakdown. What were the other conditions?
Stay away from the address on Northside Drive and have no alcohol, drugs, or weapons.
Okay, thank you.
Mr. McClendon, it seems like you have some questions and concerns. The best thing to do is to speak to your attorney, but if you have a limited bond question, I can hear that.
Yes, ma'am. I recently just got out of prison. I just spent $500 on Christmas to my stepchildren. If you could at least ask for you to drop it down to $1,000, that I would have to the 10%. I would have to pay like 1,000 of the 10%. I mean 10% of the 1,000. You see what I'm saying? Instead of 1,500, because I see that you said 3,500, and only 2,000 of that was good. See what I'm saying? So if you could drop it down to like 1,000, I could pay like 100 to 150 today. You see what I'm saying?
The bond is going to remain as set, sir, but it should be about 150 at that $1,500. Okay. All right. Best of luck to you, Mr. McClendon.
I don't need sandwich. Yeah, traffic tickets.
Petitioning, Your Honor, can you hear me?
I can. Good afternoon.
Good afternoon. I thought I was having issues with my microphone, but we have position 11 before you, Ms. Crowley.
Has South Annex heard their rights?
Yes, Your Honor.
All right, thank you. All right, Ms. Crawley, your case is 22 CR 008470H. In that case, you're charged with theft by taking with the offense date of December the 4th. You understand your rights?
Yes.
All right, Mr. Howard.
It's a risk.
Oh, okay. Thank you. All right. Whose case is this for the state? Is it Ms. Mitchell?
It's mine, Judge. I
Okay,
apologize.
Ms. Brown. Ms. Brown,
Yes.
please proceed.
Yes, Judge. When the police arrived at 5517 Kingsport Drive in Sandy Springs, they spoke with someone from Buckhead Pizza Company that told them that the defendant had ordered pizza and a Coke. When the driver arrived, the defendant took the pizza and Coke and closed the door without paying, the total being $37.21. Judge, we're just asking for a $1,500 SOB on this one and stay away from Buckhead Pizza Company.
The pizza was delivered to her home, correct? So,
Well, yes.
okay. All right, thank you, Ms. Hogue.
Your Honor, we don't object to the state's recommendation. We just ask you follow the state's recommendation for the signature bond.
All right. At this time, defendant will receive a $1,500 signature bond to the jail. She's to stay away from that pizza company and not order any pizza from that location during the pendency of this action. Is there anything further?
No, Your Honor, nothing from the defense.
All right. Best of luck to you, ma'am. Who do we have next? I'm sorry, position 26.
Yes, Your Honor, 26, Ms. Watts.
Watts.
All right, good afternoon, Ms. Watts. Your case is 22 CR 008471G. In this case, you're charged with driving on expired or no license plate, no insurance, and willful obstruction, each with the offense date of December the 22nd. Do you understand your rights?
I understand what you just said. You said there are rights.
You have rights. You have a right to remain silent. You have a right to an attorney. And this proceeding is broadcast over the internet. That means everyone can see it. Do you understand that?
I understand that. Yes, Your Honor.
All right. Thank you. Mr. Howard?
7 total. Last arrest was in September. Suspended registration, suspended license, fleeing an officer. I was bound over to Fulton County from the city jail. August 2022, suspended license dismissed. June 2022, trespass and obstruction. She got first offender for aggravated cruelty to animals and PI from 2017. That's it.
All right. Thank you. Ms. Mitchell?
Yes, Your Honor, in this case, the defendant was seen driving without an affixed license plate to the rear of her vehicle. Officers initiated a traffic stop by turning his blue lights and sirens on, but the defendant continued to drive without stopping. Officers reactivated the sirens to alert the defendant, and she suddenly stopped her vehicle. After several verbal commands to pull over, the defendant refused and did not comply. Officer exited his patrol vehicle and approached the defendant, who was now impeding all lanes of travel heading northbound. So she was within 2 to 3 lanes, Your Honor. Upon further investigation, it was discovered that the defendant's vehicle was also not under insurance. Your Honor, the state is recommending a $3,000 surety bond on this case. As to count 1 and 2, it'll be $500 surety each, and count 3 will be $2,000 surety, along with the conditions of no alcohol, drugs, and weapons. Your Honor, that's aside from these allegations, that's also going to be in addition to the history. She does have 2 open cases, one for criminal trespass and obstruction, which is a similar charge as the obstruction in this case. And then she also has criminal trespass also from this year, one in April and one in June, both in Douglasville. So based on that, we are recommending the $3,000 surety bond. Nothing further, Your Honor.
All right. Thank you. Ms. Cook?
Yes, Your Honor. Ms. Watts has been in, well, she's a native of Georgia. She left briefly and returned. She's been here for the last 6 years. She's on a fixed income, Your Honor. She, as it relates to her vehicle, is my understanding that that has actually been her home. She's residentially challenged for the last 11 months. However, she does receive mail at her mom's address. She does financially, Your Honor, she's just not able to afford any sort of bond. As a result of this incident, her vehicle was towed. She adamantly disagrees with the facts of the case. She asserts that she did have a proper license plate affixed to the back of her vehicle, but there was a bicycle, I believe, on the back that may have been blocking it from being viewed. She is adamant that she has insurance coverage. She provided me with the insurance company name. However, due to the limited time, I was not able to verify coverage for her. And as it relates to the officer, Your Honor, it's my understanding that at the time this occurred, Ms. Watts was on the phone with her daughter, who would be a witness when she does bring this forth to trial, and that the officer was overly aggressive and threatened her with the taser, and that is why she remained in her vehicle, is my understanding. Your Honor, because of her financial status and it's the holidays, Your Honor, we're asking the court to give her a signature bond. We'll leave the amount to Your Honor.
All right, at this time, defendant will receive a $3,000 signature bond through the jail. She's to have no alcohol, drugs, or weapons as a condition of that signature bond. It'll be $1,000 on each count. Is there anything further?
No, Your Honor.
No, Your Honor.
All right, best of luck to you, Ms. Watts. Who do we have next? 29, Longest. Good afternoon, Ms. Longest. Your case 22 CR 008474Y. In this case, you're charged with battery and family violence with the offense date of December the 22nd. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard, second arrest. Can you put the first arrest on the record, please?
Yeah. 2017 shoplifting dismissed.
Okay. All right, thank you, Ms. Mitchell.
29. I'm sorry, I pulled up the wrong case. Yeah, Your Honor, in this case, the defendant battered her live-in boyfriend, Mr. Austin McLinn, spelled McLinn, by punching him in the face several times, leaving him with a bloody nose and swelling under both eyes. It started when the victim and the defendant were walking back home from North River Tavern when they got into a verbal dispute that turned physical. The defendant attempted to take Mr. McLinn's keys that were attached to his pants. They began wrestling as he didn't allow the defendant to take his keys. The defendant's wig came off during their tussle. And Mr. McLinn stated he did not hit the defendant at any time, nor was there any visible injuries to the defendant. Your Honor, the state is recommending a $3,000 surety bond, no further contact with Mr. McLinn, a stay away from incident location, 2001 Sandalwood Drive, Sandy Springs, Georgia, 1-day anger awareness, and no alcohol, drugs, and weapons. And Your Honor, that's primarily due to the what's alleged in these facts, Your Honor. Nothing further.
All right, I'm gonna sound for Mr. McLinn. I don't see that name on the Zoom conference, so we'll go to you, Ms. Cook.
Thank you, Your Honor. Ms. Longest is 23 years old. She does not have any children. She's a high school graduate from South Atlanta in 2017. There she ran track. She then got a track scholarship. She did some college, I believe at Life University, maybe. I may have that incorrect. But she recently was also in chiropractor school. Your Honor, as far as the allegations are concerned, she adamantly denies the allegations against her. And in fact, we would assert that if anything, she was acting in self-defense and she was not the initial aggressor, the complaining witness was. It's also my understanding, Your Honor, that at the time, she was the one who actually tried to call 911. The 911 call would have came from her phone, although he was the one who may have been talking to them. And that's because he took the phone from her. Your Honor, it is our position that he swung her into a wall, swung her wig off and threw her into the ground. And for that reason, Your Honor, she was therefore defending herself. In my brief conversation with her, she was very emotional about the situation. She has no issues at all with the stay away from the victim. It's probably in her best interest for them to stay away from each other. Your Honor, she does have family in the area, her cousins. However, her mom actually lives in Richmond, Virginia. And she would be asking because other than this address that they share together, I'm not sure if she will be financially able to afford any other location in Georgia. So we would ask the court for a signature bond in this case. She definitely wants to come back and clear her name as it relates to these particular charges. She has no issues with any stay away conditions during any sort of one-day anger awareness class. But we would ask that if the court is inclined to give her a signature bond, and then upon completion of those conditions, allowing her to return to Richmond, Virginia to be with her mom. And then she would definitely come back to court as it relates to fighting these charges against her. Nothing further from the defense.
All right, defendant will receive a $4,000 signature bond per
Your Honor,
judge.
if I
Yes.
may state, this new information that defense is relaying was not told to the officers, and it was not in the officer's report, just so that you know.
Okay, duly noted. $4,000 signature bond through pretrial services. She's to take the one-day anger awareness course, have no contact with the alleged victim, and stay away from the incident location. Should she need to retrieve any items, she can do it with a one-time escort from law enforcement. She's to have no alcohol, drugs, or weapons. As long as she complies with the pretrial requirements and appears in court, she can return to where her mother resides. All right.
What is
Anything
this
further?
address?
I have 2011 Sandalwood Drive. All right.
2001.
No, 2011 Sandalwood.
Oh.
It's 2001.
Oh, okay. You were right. I was wrong. 2001. All right. Best of luck to you, ma'am. Who do we have next?
Position 21, Mr. Fan.
All right. Good afternoon, Mr. Fan. Your case is 22 CR 0084618. In this case, you're charged with 1, 2, 3, 4, 5, 6 counts of promoting or organizing an exhibition of illegal drag racing with the offense date of October 16th of 2022. Do you understand your rights?
Good afternoon, ma'am. Yes, ma'am.
All right, thank you. Mr. Howard, can I have the history, please?
Second arrest. Last was back in February in Gwinnett for trespass. Unlawful for a person to participate in criminal street gangs. Promotes or organized drag racing or land drags.
Okay.
Let's see, the unlawful for street gang was dismissed. Both counts. I'm not sure what happened with the other one. He got a hold out of the cab, a traffic offense. I think it might be similar to this. That's it.
Okay, thank you. Ms. Mitchell?
Yes, Your Honor, in this case, on October 16th of 2022, officers responded to a street racer call on I-85 southbound at 17th Street. Upon arrival, street racers had shut down the highway and were participating in street racer activities. This was all over the news, Your Honor, so I'm sure you recall this incident. Not only was the highway shut down, but there was firing of fireworks, drones in the air, and multiple individuals walking on the highway. One of them individuals being the defendant. He ran from the officers, but was caught. Your Honor, the state's recommendation in this case is going to be a $6,000 surety bond. That's $1,000 as to each count, and no alcohol, drugs, and weapons. And that's going to be due to the defendant's affiliation with street gang activity. I believe the charges in February of this year that were dismissed were due to pretrial diversion. And in this case, in this situation in October, a lot of the defendants that were caught were there in relation to street gang activity as well. So with that being said, we are recommending the $6,000 surety bond. Nothing further, Your Honor.
All right, thank you. Ms. Cook, is this your case?
Yes, Your Honor, it is.
All right, please proceed.
Mr. Fan is 25 years old. He's self-employed. He works in the media production, has his own LLC, has had it since 2019. He's lived in Georgia all of his life. Your Honor, as it relates to the charges against him, obviously we're asserting that he's innocent unless the charges are proved against him. We are asking the court to grant him a bond on this count. We're asking for a signature bond. If the court is not inclined to do that, Your Honor, we would be asking for a bond in the amount of $500 on each count, as that would total, I believe, $3,000 maximum. Thank you, Your Honor.
All right, at this time, defendant will receive a $6,000 surety bond, $1,000 for each count, and he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
No, Your Honor.
How much was that?
6,000, 1,000 each count, surety. All right, best of luck to you, sir. Who do we have next?
Position 25, Mr. Stovall.
All right, good afternoon, Mr. Stovall. Your case is 22 CR 00846J. In this case, you're charged with loitering, prowling, and criminal trespass with the offense date of December the 22nd. Do you understand your rights?
Yes, ma'am, I do.
All right, Mr. Howard.
13 total. He's on probation for trespass. 22 CR 006362J. In September, they gave him probation for that. He got history out of the state of Tennessee. Last arrest was 2019, theft of property conviction. 2019 FTA. 2018 probation violation. 2016 theft of property conviction. Failed to appear. From 2016, another theft conviction, assault bodily injury. That arrest occurred in 2015. You want me to keep going?
No, that's good. Thank you. Ms. Mitchell?
Yes, Your Honor, in this case, the defendant criminally trespassed onto the reserve. Oh, let me start by saying that this is the co-defendant case with position 3.
Okay, thank you.
Yes.
This is the one where they're staying in the apartment.
Yes, Your Honor. And they were actually squatting
in
the vacant apartment. Yes. Your Honor, I'm actually going to be requesting that the bond remain the same. This already has a current bond of 5,000 surety, 2,500 as to each count. In addition to that, with conditions of stay away, no alcohol, drugs, or weapons. That is because the defendant does have an open criminal trespass case from September of this year. The defendant, we also have concerns. He is a flight risk. He's a multi-state offender and convicted felon. He has at least 5 FTAs from what I could see. He has an evading arrest conviction and 2 counts of violation of extradition convictions in 2016. So he is a higher flight risk than the other defendant. So we are requesting that this bond remain the same. Nothing further, Your Honor.
All right, thank you. Ms. McLeod?
Yes, Your Honor. My client is 29 years old. He is a classical musician. He tells me that he earns his living by offering lessons to students online. He denies that he went into this location at all, Your Honor. In fact, he said he was invited by the co-defendant whom he had just met. He was invited to this apartment. He thought the apartment belonged to the co-defendant, and that was the reason why he was there. He did not know that it was unoccupied, and he asserts that he believes there may be video which will show that that was the case, that the co-defendant was the one who went into the apartment and he came in behind him on invitation. Your Honor, I do acknowledge that my client does have some history, but in this case, it was just a matter that he did not know. He certainly was not living there or anything. He told me that he was invited there and he actually fell asleep and was surprised when the police officers came. He is not in a position to afford a $5,000 bond, Your Honor, so I would ask the court to consider giving him a more reasonable bond, say maybe $1,000, because this is a criminal trespass case. It is not a crime of violence or anything, Your Honor. It is what would be regarded as a property crime. Nothing further, Your Honor.
All right, at this time, defendant will receive a $1,500 surety bond, 500 count 1, 1,000 count 2, and he must stay away from the incident location. Excuse me, and have no alcohol, drugs, or weapons. Is there anything further?
And nothing further, Your Honor. This concludes my business before the court. May I be excused?
Yes, you may, Ms. McLeod. Take care. Have a great holiday.
Thank you. The same to you, Judge. Thanks.
Okay, bye-bye. All right, who do we have next?
Position 24, Mr. Sims.
All right, good afternoon, Mr. Sims. Your case number is 22 CR 008464A. In this case, you're charged with public drunkenness and criminal trespass with the offense date of December the 23rd. Do you understand your right?
Yes, ma'am.
All right, Mr. Howard.
22 total. Last arrest was last month in Chambly for shoplifting. September trespass, PI on Marta. He was arrested in July for criminal trespass out of Doraville. April of this year, FTA for public intoxication. March, trespass. Got a disorderly conduct arrest from February 2021. 2015, failed to appear, not prosecuted. He got some more FTAs from 2014.
That's good. Thank you. Ms. Mitchell.
Yes, Your Honor. In this case, the defendant was seen accosting other patrons by using profanity in a threatening manner. Officers asked the defendant to leave. And also, Your Honor, this took place in College Park MARTA station. Officers asked the defendant to leave, and the defendant left and quickly returned to accost other patrons in the same manner. Officers placed the defendant under arrest and could smell a strong odor of alcohol coming from his person. A MARTA suspension check was conducted, and the defendant had an active suspension effective on October 30th of this year with an end date of December 29th of this year. Your Honor, there's a current bond of $2,000 surety. That's $1,000 as to each count, and the state's going to request that bond remain the same with a stay away from the College Park MARTA station located on 3800 East Main Street, College Park, Georgia, and no alcohol, drugs, and weapons. Your Honor, our biggest concern here is defendant's risk of reoffense and him being a flight risk. He has 5 open cases, one of them being already a criminal trespass to MARTA this year. He also has a criminal trespass that was amended to disorderly conduct conviction in 2013. But out of the 5 open cases that he has, let me see. 4 out of the 5 are from this year. 1 is from last year. He has 3 criminal trespass open cases right now. So he also has at least 4 FTAs from what I could see on his record. So based on that, we're recommending a $2,000 surety bond. Nothing further.
All right. Thank you. Ms. Cook?
Yes, Your Honor. We agree that Mr. Sims does have a history. We do not dispute that. However, he has been in Georgia for more than half of his life. He does have 4 children. He is employed, actually. He does janitorial work. It's my understanding, Your Honor, that previously his life circumstances were different than they are at the current moment. Previously, he didn't have transportation. He was residentially challenged. However, at current moment as it stands, he is able to live with his sister. So he does have somewhere like stable housing. So, Your Honor, he honestly financially cannot afford to make a $2,000 surety bond. Although he is employed, it's still a low income situation. So we are asking the court to grant him a signature bond. Your Honor, I understand that he does have prior FTAs and he does have prior criminal trespasses, but Your Honor, that is honestly just a result of his life circumstances. And thankfully, those have changed and he is making strides to do better. So we are asking Your Honor to allow him a signature bond so that he can get out, maintain his employment, and fight the allegations against him. Nothing further from the defense.
All right. At this time, defendant's going to receive a $500 surety bond. That's $250 on each count. And he has to stay away from the College Park MARTA station. Is there anything further?
No, Your Honor.
All right. Best of luck to you, sir. Who do we have next?
Position 27, Mr. White.
All right. Good afternoon, Mr. White. Your case is 22 CR 008472B. In this case, you're charged with simple battery family violence with the offense date of December the 23rd. Do you understand your rights?
Yes, good afternoon.
All right, good afternoon, Mr. Howard.
24 total.
Sure.
On probation, simple battery DV. In January, they gave him 12 months for that. That's 20 CR 002963B. Got an open ag assault DV, terrorist threats, possession of a firearm during the commission, use of a firearm by a convicted felon. That's 22 SC 185085. Also got an open case for 2 counts of battery DV, 22 SC 181271. You want more? Or that's enough.
That's sufficient. I think I've heard what's relevant. Miss Mitchell.
Yes, Your Honor, in this case, the defendant battered his wife, Mrs. Katrina, spelled Katrina, Nelson, by pushing her into a refrigerator in the home. Both have been legally married for 3 years and live in the same home. Your Honor, the state's bond recommendation in this case is going to be a $5,000 cash bond, no further contact with the victim, Mrs. Nelson, a stay away from the incident location 2485 Woodbend Lane, Riverdale, Georgia, 1 day anger awareness, and no alcohol, drugs, and weapons. And Your Honor, that's going to be due to his criminal history at the moment. There's a high risk of reoffense in this case. The defendant has 3 open cases. As you've heard from pretrial, the case, so I'm just going to start from the top. The battery, he has 2 charges of battery family violence from January of this year. Although this is a different victim, it is a woman that is involved as well. And I believe he received a $20,000 surety bond in that case. There's aggravated assault, family violence, terroristic threats, possession of a firearm, and use of firearm by a convicted felon in 2020 that is also open. Now, this is the same victim, and he received a $10,000 surety bond in that case. The other case is another battery family violence from 2016 that involved a different victim, but was a woman. So the victim in that case is the same victim from the January battery family violence case. And that appears to be on a judicial hold, but he received a $5,000 surety bond on that case. And I believe that's due to FTA. Your Honor, he also has a simple battery family violence conviction in 2018 and a battery family violence conviction in 2014, which is another woman. So based on his history, we are recommending the $5,000 cash bond, and he does have several FTAs, so he is a flight risk. So based on that, we're requesting cash bond. Nothing further, Your Honor.
All right, thank you, Ms. Cook.
Thank you, Your Honor. Mr. White is 42 years old. He has 6 children total, 2 of which are under 18 and reside with them. Your Honor, he's been employed for the last 4 years as a mover. He's lived in Georgia all his life. Like the state said, he has been married for the last 3 years. Yes, he does have a history, Your Honor, and he even admits that he's previously been in toxic relationships, and that he used to be a drinker, but that's no longer a concern of his. He's doing better. Your Honor, as it relates to this particular incident and the facts as alleged, he adamantly disputes those facts. He was at a funeral yesterday with his sister. There's a backstory that I'm not going to get into for time purposes, but basically the wife and the sister do not get along. He was at the funeral with his sister, came back to change his clothes. His sister was there. It's my understanding that the sister may even have pending allegations against the wife. But this is what all of this situation is a result from, Your Honor, as it relates to any conditions. If you were to give him a bond, he does have somewhere else to stay temporarily. He can stay with 2 of his older children at a different address. It's Christmas time. He has basically spent all of his finances on Christmas, doesn't have any extra money. The state's request of a $5,000 cash bond is essentially saying that he should not get a bond at all. Your Honor, we would be asking that you give him, I guess, a $5,000 signature bond with the condition not to return to the incident location and stay away from the complaining witness in this particular case. Nothing further.
Okay. All right, at this time, defendant will receive an $8,000 surety bond He's to have absolutely no contact with the alleged victim, last name Nelson, and he must stay away from the address on Woodbend Lane, have no alcohol, drugs, or weapons as a condition. Is there anything further?
No, Your Honor, thank you.
All right,
The
best
bottom line again, Judge, I'm sorry.
8,000 surety. All right. All right. I see you have a question, sir. The best thing for you to do is to speak to Ms. Cook following this. I don't want you to interfere with your rights to remain silent.
Judge, I do have an announcement.
Okay.
Position 14, waive their appearance,
Okay.
and 15, waive their appearance.
Are you
Yes.
complete? Are you complete at courtroom 2?
Yes, we are.
All right, but I want to make one announcement before I let courtroom 2 go. At going back to the case of Kendrick McClendon, 22 CR 008460Y. I am going to convert the $500 surety bond to a $500 signature bond through the jail. So he will have to bond out for the $1,000 possession of open container only. All right. Will you please convey that to Mr. McClendon?
Yes, ma'am.
All right. Thank you. Take
All right.
care at courtroom 2 and have a great rest of your holiday.
How you on? Can I speak to
All right. Who's asking to speak with me?
Sam? I want to sit down, at the moment, I kind of like work by myself and, I make all the money for myself. And I don't have no family member or no such body at this moment to reach them for them to pay my way out here. Cause I do have like 2 jobs. I work at the car wash, hands-on car wash, and I work at Style Zone in Doraville. Now y'all was living on and off with my sister, trying to make a better life, and I'm trying to get locked up or nothing like that. I just been trying to do the right thing. And I'm not no bad person or nothing like that. And
Is Mr. Sims the only person there at courtroom 2? All right. He is.
Ma'am, I'm
Is
sorry.
Mr. Sims the only defendant at courtroom 2?
They're about to leave.
All right. Mr. Sims,
She's
what
still-
we will do, I ordered, what was it, a $500 surety bond?
yes, ma'am.
And a stay away. All right, we will convert this as a one-time act right. Do not go back there. Mrs.
Yes,
Sims,
ma'am.
you will receive a $500 signature bond through the jail, $250 each count. All right.
Ma'am, thank you.
All right, we don't want to see you back here. Take care. Merry
Oh, wait,
Christmas.
ma'am. Merry Christmas.
All right.
Your Honor, this was the case where he has 5 open cases. You
I
said,
I'm aware. I'm aware.
Okay,
Thank
okay.
you, Ms. Mitchell. All right, let's go to our waived appearance cases. Let's first take the case of 14, position 14, Tracy Ellett, 22 CR 008467G. Is Miss Ellett in quarantine, or this is a medical waiver, Ms. Hogue?
Yeah, Miss Ellen's in quarantine. She's in isolation. So it's a waiver, a medical waiver.
All right. Mr. Howard, can I have the history for that case?
8 total. Last arrest was 2018, failure to comply. DWI. The failure to comply was dismissed. DWI was a conviction. That was out of North Carolina. 2011 DWI. 2005 out of Texas for fugitive. Failed to ID fugitive from justice. Theft of property. Everything else is older. This
All
is
right,
first
that's
Georgia
fine.
arrest. And a
That's
resident
fine.
of Gastonia, North Carolina.
Oh, okay. All right, Ms. Brown.
Yes, Judge. She in this case, she was at 232 Forsyth Street, which is the Greyhound bus station. She had asked them for a refund. They had given her the information information on how to retrieve a refund and asked her to leave the premises and had to ask her several times, which she refused to do so. And so the police were called. Given her history and her lack of ties to Georgia, we would ask that the bond remain as is currently at a 2,200 surety and a stay away from the Greyhound at 232 Forsyth Street.
All right, Ms. Hogue.
Yes, Your Honor. Miss Elliott is a quintessential planes, trains, and automobile trying to get see her family over Christmas. She did. In fact, she was not trespassing, Your Honor, because she had a valid ticket. This is a classic situation of she had a ticket from North Carolina to Austin, Texas. She was supposed to make a connection in Atlanta. Due to all the delays, as you know, from weather and the Christmas travel, that connection was missed. So then she was trying to reschedule. Now, I'm sure everybody was tired, frustrated, and everything else because of all the delays, but they were less than every time they kept telling her to go do something and come back, she'd go do it and come back, go do it and come back, go do it and come back. She spent her whole time, including getting her possessions stolen here in Atlanta, simply trying to get to her family in Austin, Texas for Christmas. She's abandoned that idea completely at this point, Your Honor. All she now just wants to do is get back to North Carolina as quickly as she can. She's managed to call the bank regarding her. She's spending almost a day in that Greyhound station trying to get reconnected so she could get to Austin, Texas. So it was very frustrating to go out, come back, go out, do all the things they kept asking her to do while she was trying to reschedule something that was to not her fault because of delays. And now she got her purse and everything else stolen. She was able to get another card and get everything else. So all we're asking for at this point, she qualifies for our services. She has a stable address in North Carolina, and we have connection and information for her to take care of this. We do believe this will be dismissed because she had a valid ticket. She was trying to get corrected so she could, in fact, get to Austin, Texas. So I would submit that number one, she isn't even guilty of criminal trespass because she was just trying to reroute her ticket appropriately. So we are asking for a signature bond at this time so she can simply be released and just go back to North Carolina because she's not going to make it home to Austin, Texas to see her family.
All right, defendant will receive a $2,000 signature bond through the jail. She's to stay away from the Greyhound bus station. Would that impede her ability to get home, Ms. Hogue?
No, from what she tells me now, she finally got her paycheck on Friday. She should be able to make other alternative routes. She doesn't want to go back to Greyhound at this point either.
All right, so she must stay away and have no alcohol, drugs, or weapons. All right, now we'll move to the case, of Christopher Fanning, 22 CR 008448C, in which defendants charged with simple battery against a police officer or police dog with the offense date of December the 21st. Can I have that defendant's history, Mr. Howard?
He's on probation, 2 counts of ag assault, 16 SC 148564. 2018, they gave him 9 years probation for that. 2019 probation violation, 2020 FTA, 2020 shoplifting conviction. He had a first offender for robbery that was sealed. 2016 ag assault. Okay, that was the probation. That's it. He was supposed to go to felony earlier. They reset him so that they could try to get in contact with the victim.
Okay. Okay. Ms. Mitchell?
Yes, Your Honor, in this case, the defendant battered a detention officer by slapping him in the face. The detention officer was escorting the defendant over to ID and fingerprinting area when the defendant disobeyed verbal commands to place his hands on the machines to be printed. Instead, the defendant slapped the officer. Your Honor, there's a current bond of $1,000 surety on this case, and the state's going to request that that bond be increased to a $5,000 surety with 1 day anger awareness and no alcohol, drugs, and weapons. Your Honor, as heard from pretrial, the defendant has an open aggravated assault case from this year, December of this year, that is open. He also has a conviction, which includes 2 counts of aggravated assaults, possession of a knife during commission of a felony, and simple battery in 2018. So we do believe there is a risk of reoffense in this case. The defendant also has a FTA, so he is a flight risk as well. With that being said, we're recommending the $5,000 surety. Nothing further, Your Honor.
All right, thank you, Ms. Hogue.
Yes, Your Honor. Mr. Fannin is in medical right now for potential MH issues. Okay, relating to, and obviously he also has a felony arrest for which he doesn't even have a bond at this point in time. Given the status of things, we're just asking the bond remain the same. We don't believe any bond could be made by Mr. Fannin to begin with, much less whatever's going to happen with his felony case at this point. And given his potential MH issues, until those are ironed out, we just ask that the bond remain the same at this point.
Are you requesting an eval at this point, Ms. Hogue?
I believe we're going to have the social worker go out and do the interview first and then potentially see whether or not we need an eval.
Okay. All right, defendant will receive a $2,000 surety bond. And was the state requesting no contact? I'm not sure that you were. Ms. Mitchell.
Because it was a detention officer, I'm not sure
Yeah.
if that would be possible.
Yeah, it's probably not relevant. All right, and he's to have no alcohol, drugs, or weapons.
Do you want?
All right.
How much was that?
2,000. I'm sorry.
Did you want no further violent contact with any employee officers in the detention?
I guess we can, yeah, that's a good suggestion, Ms. Lewis. I'm not sure how practical, but do we have the name of that detention officer, Ms. Mitchell, by any chance?
Yes, I
Is it
do.
Officer G. Moss?
G. Moss.
Okay, so no further violent contact with G. Moss. All right, I believe we've gotten our way through this very long calendar.
Your Honor, have we done position 18 or did I miss an announcement?
18 was released.
Okay, thank you.
All right, Ms. Lewis, I know you're asked to do quite a lot today, but would you please review this calendar for me?
Yes, ma'am. Give me 1 second. Let me write this last thing down. All right, everybody. Excuse me, I'm a little congested here. Okay, position number 1, the SAP date is January the 5th, 2023. So I don't have to keep repeating it. So I'll just say SAP, so everybody knows January the 5th. Okay, position number 1 is a $1,500 good bond is reset for the SAP. There was no conditions on there. Did you, Judge? Cause I didn't hear nothing.
Are you talking about position 1?
Yeah.
I have it as a signature bond through the jail, 1,500 for count 1, 500 for count 2.
I thought it was, no, number 1.
Yeah.
I thought it was all good bond.
No, signature bond through the jail.
Hold on, let me look. I've scratched through my notes.
I got 1,500 for number 1.
Yeah, I have $1,500.
Goodbye.
Nope, I have $1,500 surety.
Yeah, that's what I have. 1,500.
Yep, 15 surety. No alcohol, drugs, or weapons.
Okay. All right. Start back over again. Number 1, I have a $1,500 good bond. Case is reset for SAP. Position number 2, I have a $4,000 SOB through pretrial per judge. Reset for the notice. I have position number 3, a $1,500 good bond. Reset for SAP. Position number 4, I have a $3,500 surety bond. Reset for SAP. Position number 5, I have a $2,000 split bond, $1,000 SOB through the jail on the first charge, and $1,000 surety on the second charge. That case is going to reset for the SAP. Position number 6, I have a $2,500 split bond. I have $1,500 surety on the first one, and $1,000 SOB through the jail. That's going to reset for SAP. Position number 7, I have a $3,500 SOB through pretrial per judge, reset for the notice. Position number 8, I have a $6,000 surety bond, reset for SAP. Position number 9, I have a $500 surety bond, reset for SAP. Position number 10, I have $1,000 surety bond, reset for SAP. Position number 11, I have a $1,500 SOB through the jail, reset further notice. Position number 12, I have a $2,500 SOB through the jail, reset further notice. Position number 13, I have a $3,500 SOB through pretrial for judge, reset further notice. Position 14, I have a $2,000 SOB through the jail, reset further notice. Position number 15, I have a $2,000 good bond, reset for SAP. Position number 16, I have a total of a $5,000 SOB through pretrial per judge. Position number 17, I have a $8,000 surety bond, cases reset for SAP. Position number 18, that was 17. Position number 18 is release, cases reset further notice. Position number 19, I have a $1,000 split bond, $500 good on the first charge and the $500 SOB through the jail on the second. Cases reset for the SAP further notice. Position number 20, that bond was adjusted. It's still a $35,000 split bond.
3,500?
3,500, sorry. Split bond, $2,000 is gonna be an SOB through the jail and $2,500, sorry. It's gonna be an SOB through the jail and $1,000 surety. That's gonna be on charge number 4. Is that correct?
Yes, that's correct, Ms. Lewis.
Okay, and the case is reset for the SAP for the notice. Position 21 is a $6,000 surety bond. Case is reset for SAP. Position number 22 is a $198 surety bond, reset for SAP. Position number 23, I have an $8,000 surety bond, case is reset for SAP. I do have a question on the location. What is the stay away address? I didn't get it.
I'm sorry, what position, Ms. Lewis?
23. What was the stay away? Was it Sonoya Row or Ginger Cake Row?
23 was Senoia, spelled Senoia.
So it was Sonoya Row, stay away?
Yes.
Okay. Because I heard 2 addresses and I wasn't certain. All right, thank you. Position number 24, that bond was also adjusted. It's gonna be set further notice. It's a $500 SOB through the jail. Position number 25 is a $1,500 surety bond. Reset through, cases reset for SAP. Position number 26 is a $3,000 SOB through the jail. Reset for the notice. Position 27 is an $8,000 surety bond. Reset for SAP for the notice. I'm sorry, reset for SAP, not for the notice. I'm getting ahead of myself. Position number 28 is a $1,000 SOB through the jail. It's reset for the notice. Position number 29 is a $4,000 SOB through pretrial, reset for the notice. That should take care of everything.
That's all.
Corrections?
Any comments, changes, corrections, questions? All right, hearing none, we made it through in good time. Thank you, everyone, for your cooperation today. I hope everyone has a great rest of your holiday. Take care, stay safe, and stay warm.